Sì, 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 Oli, sì, 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 sì.
तुम्हें पता था?
Who's appearing in the curative?
Please no. I appear for the petitioner.
I'm appealing for the union matters.
Yes.
So page 24 is the order, my lord. My petitions are dismissed on the basis of R.R. Pillai. My lord, the petition before CAT, High Court and by this court also. And that if your lordship sees page 24 is the order of reference
Yes.
to the curative petition.
Yes.
Yes, it refers to R.R. Pillai to the larger bit. Please see, my lord, page 24, para 2 onward, para 3 onward. May I read, para 3? Learned Counsel for the Appellant Union has placed reliance upon the 3-judge bench judgment of this court in R.R. Pillai, reporting so and so, which in specific terms says that Muhammad Aslam referred to above was not correctly decided. Placing reliance on the above, R.R. Pillai judgment, Learned Counsel for the Appellant Union of India states that the appeal of Union of India deserves to be allowed. On the other hand, Sri R. Basan, Learned Senior Counsel for the Respondent, and Sri Arvind so and so have relied upon an order dated so and so, passed in civil appeal number by a 3-judge bench, approving the following judgment in the case of Muhammad Aslam. The order dated 5th February 2001 reads as follows. The LRs of deceased respondent number 2 are brought on record. The respondents are the employees of unit-run canteen at Jodhpur. The question involved in this case is fully covered by the judgment of this court in the case of Union of India versus Aslam. The civil appeal accordingly stands disposed of in terms of the said judgment. Now please see para 8. In that view of the matter, we find ourselves in difficulty and accordingly, we are of the view that the matter requires consideration by a larger bench. Now, if your lordship sees my SLP at page 61 and at page 64, the CAT dismisses my petition only by relying upon R.R. Pillai. Then High Court at page number.
And according to you, R.R. Pillai has been doubted and referred to.
Doubted, and it is referred to a larger bench, and it considers 2001 order. At that point of time, we were not aware about the 2001 order, nor me, nor the other side. So that was not placed before your lordship.
Let's be very clear. R.R. Pillai
Yes.
examines LIC. It examines the entire history by which the unit canteens were established.
Right.
Earlier, they were wholesale canteens which are managed by the government, by the army. Those are covered under they'll be government servants. As far as unit canteens are concerned, there used to be no unit canteens. It's what being done by private contractors. Then the chief of the army staff then formulated a scheme where he felt that this work should not be, the profit should not go to the contractors, but it should be really recycled and given to the soldiers, the army men. And therefore, he set up this system of unit canteens. Now, unit canteens are never been government employees till now.
Yes.
They've never been paid out of the consolidated fund of India. Never been paid. It's an in-house mechanism by which they sell, and these are more or less like a cooperative movement with some element of philanthropy built into it, because the profits generated are then used for the army men. Now, if we go to bring in that, it's going to upset the entire system. Probably they'll have to close them down.
Please see the Aslam judgment. Aslam judgment looks into that and say that since
Aslam judgment is just a paragraph.
Yes, but
it's just a paragraph. It's
on the basis of that paragraph, they have framed rules in 2001. That I'll also show.
Some rules have been framed.
Yes, in 2001 on the basis of this Aslam judgment, which I have annexed to the petition. First,
let's have a look at those.
Means the way rules have been framed. Have rules been framed on the basis of Aslam?
I have got those copies. I'll show it to you.
They were framed and they were amended also, my lord.
No, rules may have been framed.
Yes.
Rules have been framed treating them as government employees.
Yes.
But is the payment being made out of consolidated fund of India?
Now, that doesn't say so, but then on the strength of this Aslam judgment, they frame rules and then comes.
Let's have a look at the rules. Let's have a look at the rules.
Technical objection to this before my lords are going on the merits. Let's just see, this Vinod Kumar's came on 14 September 23. They filed the curative in 22 itself. At that time, this wasn't.
That doesn't make a difference.
We're now relying upon the subsequent.
Look,
entire pleadings, the affidavit.
Look, the matter is whether it's curative or the matter has been referred to the larger bench. Then also it's the same thing. Let's not go in technicalities.
I just wanted to place it before my lord, because the affidavit is also dated back. Thereafter, the entire pleadings have been changed. The affidavit hasn't been changed.
You will have to meet this argument in either way, either in the curative or the larger bench.
What do the rules do? Do the rules recognize them?
No.
Have you looked at the rules?
My instructions are that they are not being paid from the Consolidated Fund of India, and they are not treated as government servants.
So the money goes over.
I show that
The sale proceeds, etc., must be also coming to a separate bank account, which has got nothing to do with the government of India.
Yes, because it's a separate account.
So it is not funded by the government from the consolidated.
now I must tell one
Mr.
factor.
Chaudhary, if we start now making all these people as government servants, I mean, ultimately, this will be impossible.
But I tell you actually one factual aspect. Half of them are treated as government employees by relying upon Aslam. Half of these employees similarly situated. My friend can take instruction to that effect. So half of them who are junior to me, similarly appointed, they are treated as a regular employee by relying upon Aslam. Now we, some of us, they are not treated as government employees, nor they are treated as contractual labor, contractual employee. So half of them are discriminated, half of them are relied upon by Aslam judgment, half of them are treated as contractual employees on the basis of RRP license. So therefore, this needs to be considered along with those judgments.
Affidavit,
Because Aslam what is
you consider this submission and you file an affidavit, because if there is factually a discrimination between half the employees, who are treated as government, look at it. We are not disposing it off today, and apprise us after filing an affidavit on facts what the factual position is.
I find that or what I want to bring to my lord's attention is R.R. Pillai's 3-judge bench, which overruled Aslam, and that is why from 2009,
Now R.R. Pillai has been doubted.
So what happened was, let's be clear, R.R. Pillai wasn't aware of the short order passed in the other case also of 3 judges, accepting the plea taken in.
No, it has not been decided, but that's
Probably that order was never
it's
circulated.
not in merits, my lords. That's our
Maybe you may have a point there, but it's a confirming order giving reasons. So whether the principles of precedent will apply on the basis of that, whether it becomes a ratio decision.
And you consider this position and file a proper affidavit.
file.
Let us have a overall perspective of what's the position in regard to other unit run canteens. Half of them treated as government employees.
we'll file an affidavit.
Because obviously after that
Better.
judgment, some of them would have been treated as government employees.
Bearing in mind the issues which have been raised in the curative petition, there is the view that the ends of justice would require a factual elaboration by the Union of India on the status of the unit-run canteens and their employees. Full stop. Ms. Archana Pathak Dave is, according to your request, granted 3 weeks should be granted. 3 weeks time to file a reply, to file an affidavit explaining the position. List thereafter.
I'm so good.
May I request, there is a criminal contempt petition that was filed on 20th September, but it was not registered yet. It is,
You must have not removed defects.
no, my lord, it is under instructions, I am told. It is awaiting instructions.
I'll pass orders today. I'll be
I
strict.
mean, your lordship's name permission may mention.
1 second, yeah. Anybody here?
May mention.
Yesterday's order. What do you want us to say? We have said that. Just take the mic. What have we said? May take a
My
may?
lord said, we would request the High Court to endeavor to take up the petition before the results are declared. And
Take up doesn't mean just take it up formally. Take up means, when we say that to the High Court, they're High Courts. They're not some subordinate court that we can direct them.
once more.
So when we say that, we've made our intent clear. We show some dignity to the High Courts also. So we have said take up. Take up means, you pass orders. You can't we've all been High Court judges, and I believe it.
An order passed by
1 second. Yeah, yes.
Lordship also mentioned, I want to modify my review petition. I want to file withdrawal action. I just withdraw and modify action.
You file amendment right now. You file your amendment. We'll take it on board. Yes.
You are not. How about no take action?
Give us your amendment. Give us, sir, give us your amendment. If you have an amendment, give it to him. We'll allow.
Sir,
I am seeking permission to mention one matter, my lord.
You made your point. Yes, I made my point. Yes.
Your Lordship's bench passed an order in relation to medical admission law, where my father is a gallantry police officer. The Lordship passed an order granting me an interim order. This came on 14. But it didn't come on 14, didn't come on 18, didn't come on 21st. It will now be, my lord.
In that week after the
My
Diwali.
lord, the counselling will be over. It has to be on Friday.
All right, I just
Given the order.
yes.
The Mullaperia matter, is a Lord, what requires is.
Circulate an email.
Lord, in 2006,
Mr. Nedumbara,
yes.
circulate an email. It'll be a
Yes.
little more comprehensible. I'll pass an order by the
Yes,
afternoon
yes.
for listing. Just circulate an email.
Yes.
Yes.
I am requesting to mention one matter, my lord.
Mr. Mehta.
My lord, may I have your lordship's leave, my lord? There's an IBC matter where the resolution plan has been set aside by the High Court. This matter had been.
It's a fresh matter.
No, this matter had been mentioned to your lordship. my lord.
Circulate the email.
No, I'm just pointing out.
Circulate an email. I'll pass an order on it. I'll at least know what's happened.
It's now shown in the advance list for 4th. I don't want it to be deleted.
All right, NTD. Yes, not to be
My lord,
deleted.
may I repeat the matter?
I am requesting for permission
Focused on
for mentioning one
29-4
matter.
and directed the listing of matter in the 12th July 2024. It has appeared, it was shown.
All right, just circulate an email. I'll pass orders on your
Email,
application.
my lord. It may not be deleted, it is showing on 8/11.
All right.
8/11.
All right.
Your lordship, I permission, your lord.
The lordship had been returned on Friday, but it was on 4th of October. It was to be listed on 4th October.
All right, just send him an email. I'll mark it for that for the next available
Your
day.
lordship, permission.
Just send an email. It becomes easier for me to mark it and initiate.
Mention this matter, my lord, which pertains to medical admission, my lord, for the
Is it a fresh matter?
It's a fresh matter, my lord. I
It will
filed
come
it
up.
yesterday.
It will come up.
But
It will
my
come
lord,
up.
the last date of submission is 24. The person is disabled, my lord, is certain.
It will come up. If you have circulated yesterday admission matters, it will
I
come
have
up.
circulated an email.
It will
today.
come up. If you have removed defects, it will come up on
Your
Friday.
lordship may actually.
Friday.
Well,
Lord,
my lord,
Yeah. Lordship, with your permission, this is my warrant of possession, my lord, is scheduled on 5th of November.
When was the impugned order passed?
My lord, the impugned order was passed, my lord, the ex parte order passed in 2020, my lord, my lord, this execution was also ex parte, my lord. My lord, I am currently residing on that property.
All right, but therefore, is the petition
This is the
registered?
email, my lord, that's
Friday, correct.
Yeah,
Yes, sir.
My lord, disposition of a form, my lord, disposition of a form.
When was the-
Allahabad High Court passed.
When was the impugned order passed?
15th October, anytime, tomorrow.
15th of?
15th of October, my lord, October.
It will be listed.
Your lordship,
All
may I
right.
mention the matter to Honorable Justice Pardiwala
Your Lordship, if this matter is being heard by Your Lordship along with Justice Dhulia, the matter has been settled, Your Lordship.
Correct.
It's a case where two
Yes.
sisters were claiming
Yes, yes.
5 by 16.
The two sisters.
Yes, yes, Your
Right.
Lordship. So we have filed all the document with the registry, Your
Could
Lordship.
you not mention it before the learned senior judge?
We did, Your Lordship. Justice Dhulia has said that I'm ready to hear this
Okay.
matter any day, subject to Your Lordship.
So whatever date is fixed by my lord, on that day we will assemble.
May I mention?
Grateful.
Lordship, if I may mention. Lordship, my recovery warrants are listed on 30th of October.
Is it a fresh matter?
It's a MA, Your Lordship, I filed in and disposed of SLP.
That will be dealt with by the registry. This MA is a new illness which has afflicted the petition.
I've moved the Honorable High Court on 2 occasions. I have not been heard.
No question. The MA will be processed by the registry, yes.
May I mention, Your Lordship, I have filed in suo motu petition, that is PWD candidate in Rajasthan Judicial Service. I'm suffering from 40% of disagreement in the IA.
Is it a fresh matter?
Your Lordship, I moved an IA in the suo motu petition, seeking permission to participate in the interview for the civil.
So motor petition.
In the suo motu, Your Lordship.
Why don't you file some substantive proceeding of yourself? You know why these shortcuts? File a petition, either before the High Court or before us. But you have to file a substantive petition. You can't just jump on somebody else's petition and file an IA for substantive relief.
I'll file.
May I mention, ma'am?
I also have got an IA registered yesterday. That was listed within this week because the main matter is coming on the 5th of November. And I have been given.
Are you a party to the proceeding?
Yes, ma'am.
What is the IA for?
IA is for modification of orders. It was before Justice Mukherjee in the last day.
Just which year?
This year, Justice
Rishikesh Mukherjee. You got the names of the judges wrong, I said.
in court 4.
Just first go to the website, study the names of the judges.
But
If you make Roy Mukherjee,
Justice Rishikesh, I stand. This
first go and study the website, then I look at the come tomorrow. Yes.
Okay.
You must at least know your judges. Limit, absolutely. Yes, item 1 fresh.
Your Lordship, Mr. Uday Gupta is leading us in the matter.
The petition was withdrawn. The petition was withdrawn before the division bench. Before the division bench.
Your Lordship, the petition was withdrawn.
With liberty to make a representation. But the matter was not even liberty. It says yes. After some arguments, learned senior counsel wishes to withdraw the writ petition with liberty to file appropriate writ petitions. File appropriate proceedings. You made a representation. Representation is rejected. It's a tender matter. You can't keep on coming.
The representation was not rejected.
Anyway, that's
that was my grievance because.
Thank you.
Item 2.
Item 2.
Then Your Lordship, give me 2 minutes to just satisfy Your Lordship why this petition deserves to be allowed.
No, but it's a matter relating to tenders, and the High Court has now said that you argued the matter for some time, then withdrew it.
That is correct.
You know, when High Court judges say argued and then withdrew it, it means that when it was about to be dismissed, it was withdrawn.
Your Lordship, all I'm seeking today is that number one may take a call on my representation. They may reject it in a single line, but at least they give me that.
It's a tender matter. There's probably the contract must have already been awarded. And when the High Court said after arguing the matter you want to withdraw it and then submit a representation, if you found some way out, now you can't start re-agitating the whole thing.
Let me at least take a call on my representation.
Yes, thank you.
Very well.
What is the letter by Justice Geeta Mittal? There's item 2.
I apologize, Your Lordship. I would have to mention one thing that as for this award, there is already another SLP that Your Lordship is considering.
That's
that
right.
was at the stage of technical.
That will follow this.
Very.
Are you all agreeable to the appointment of an arbitrator?
Please, Manoj. Manoj, the opposite. There was one communication.
You're for the respondent?
I'm for the respondent. According to me, the petition is actually misconceived. Before he filed, I had already agreed to the person nominated by him.
Oh yes, you've said in your reply that that on the 27th of June, they have accepted one of the arbitrators nominated.
I don't know why this petition.
Now, which is the arbitrator of the?
Justice Kathawala from Bombay.
So,
Manoj, the issue was that the 30 days, according to the act, had expired and communication was between.
all right, we will appoint Justice Kathawala.
When the matter was listed, he could have pointed this out. I don't know why this.
One issue is that the consent of Justice Takamala was not taken before sent.
All right, we'll appoint him now. We'll say by consent of parties, right?
Please.
With the consent of the.
You've already
Both the parties are agreeable to the appointment of Justice S.J. Kathawala, former judge of the High Court of Judicature at Bombay, as a sole arbitrator. We'll start ordered accordingly. He is sole arbitrator, then the usual order.
Item 4.
Grateful.
This will have to be tagged with two other matters, or
They are all before your lordships.
all three are before us now.
The arbitration clause is admitted before the High Court. They had actually.
So we can appoint an arbitrator in all the three matters.
Live was actually has been filed yesterday. Lordship will give me some time to finish up on it.
Mr. Bandari, we can appoint an arbitrator here.
Because there is an issue here.
What is the
The issue here is that the person with whom I have a contract, he has not come and told us that he has sold these rigs to this company in UAE for BMG Gulf. In the meantime, someone else has written to us saying that we are the creditors to that
That's
company.
on
Now,
merits. That's on
maybe a real problem. What I'm worried about. He's feeding what I'm worried about, because I'll show you all the agreements and everything. But here the person who has today filed a section 11, how is he the owner of the rigs? He produces some settlement agreement. He has to show an assignment
But
agreement.
there is an agreement between you and him.
No.
In fact,
There is no agreement
I tell you
between
what
me
even
and him.
happened. This matter was wrongly
I
filed.
haven't even got a go.
Sorry?
This matter had initially gone to the Calcutta High Court by mistake, my lords. There, they admitted the arbitration clause, they admitted for the arbitrator, my lords. Ultimately, the court said we don't have jurisdiction because it's an international commercial arbitration, it's come here. So they should be bound by that statement.
Now, there the High Court and the arbitration
That order is there.
Did you file an affidavit before the Calcutta High Court admitting the arbitration agreement?
I filed an affidavit before the Calcutta High Court saying there is an arbitration clause between me and the person with whom I have the contract. And I said that in view of that, you may refer it between me and him. Now the problem is this, because I don't in principle have a problem, but I think the right course would be to implead the person with whom I have a contract, who he's claiming he has bought the rigs from. Please understand, he's a third party. He was never in the contract. I took a lease agreement, the rigs with someone else.
And the point is that you can always say that, look, I don't recognize you.
Yes.
You raised that in section 16. You raised a section 16 defense before the arbitrator.
Why don't you implead the person who has
All right, that's his call.
Tell us.
If he does
Then
not.
enter into a letter from another creditor.
That's
saying
on
they have taken
merits.
over the rigs.
That's on merits.
Please see what the.
All right, whom should we appoint as the arbitrator?
No, in Calcutta, so anybody from Calcutta, your lordships desire.
Just see what Calcutta High Court has said. Calcutta High Court said that there is some fraud here.
Indira Banerjee as the sole arbitrator.
But the problem is, does he own the rigs?
We'll keep all the rights and contentions open.
Very well. But then all rights open, but please implead the person I have a contract with.
You can move an application before the arbitrator.
Then my lords may observe that I may move an application to implead.
We'll appoint Justice Indira Banerjee as former judge of this court as sole arbitrator. The seat of the arbitration shall be Calcutta, right? All right. All the rights and contentions of the parties are kept open, leaving full stop. The respondent is granted liberty, if so required, to move an application under section 16 of the arbitration and conciliation
Very
of 1986.
Item 5.
Five.
Deputy.
When the matter had come up, your lordship said it's.
You have filed your short notes.
Yes. We hope your lordships have.
Yes.
Been circulated. Cannot see.
Our court has held that the power under section 151 could not have been used for the purpose of recall of a decree, right?
What happened, my lord, is there?
Sorry? Cannot be used. Cannot be used. That's right. Cannot be used.
That's right.
My lord, see, this question is also pointedly considered by the Honorable. My lord, the High Court judgment is fairly elaborate. Goes into a factual consideration of why the judgment which is sought to be recalled is vitiated by fraud. Enters into, my lord, I'll have to take your lordships to the
No, that we have seen, yeah.
questions of the judgment of the High Court where it has been held that it is vitiated by fraud. Fraud practiced on the court and not fraud on the party. It also held that the third party's interest cannot be affected or cannot be blocked by principles of res judicata on the ground. If it is otherwise found that an order has been obtained by practicing fraud on the court. And on that premise, my lord, the court therefore held that the final decree which was passed in 2013 is liable to be recalled. And my lord, when the matter came here, no doubt, my lord, the honorable court could consider whether an application under 151 was maintainable or not. But my lord, the application under 151 was found to be maintainable on the premise and on a factual consideration that fraud was practiced on the court. Now, my lord, if that has to be reversed, then there has to be a reconsideration of all the factual aspects which found favor with the High Court when the High Court held that fraud has been practiced. That has not been undertaken. The court expressly said we are not getting into the merits of this. And that's why, my lord, my respectful submission.
Our court says that 151 application was not maintainable at all.
Yes. And that, my lord, by your reference to 2 or 3 judgments, which also, my lord, took the view that if fraud had been practiced on the court, then my lord, 151 is maintainable.
So the issue as to whether fraud was practiced on the court should have been taken into account by this court.
That has not been done.
Because that was the finding of the High Court.
That's the finding of the High Court. My lord.
There is a distinction between fraud practice inter se between the parties and something done because the court always has the inherent power to recall an order which you have passed if it comes to the conclusion that a fraud has been practiced in the court. In fact, it is duty bound to do that.
No, my lord, but what might constitute an error apparent on the face of the record is, as a matter of law, the Supreme Court said, yes, a 151 application would be maintained if, for recall of a judgment, if fraud is practiced on the court. But this is precisely what the High Court has said. No, the Supreme Court would be entitled to reverse it. Because it's an error.
In which case, our court has to look into the question as to whether fraud has been practiced.
That's all. On its factual premise, the High Court held, not an elaborate consideration of the facts. The High Court held, this is why fraud has been practiced on the court. And if therefore the 151 application is maintainable, if fraud is practiced on the court, and this is what the High Court held, the Honorable Court could have reversed it on factual premises that the Honorable Court comes to the conclusion that the High Court was wrong in coming to this conclusion. That I will have to take a note.
So this court could have always held, according to you, that there was no fraud practice on the court. But we have to go into the merits to
But we have to go into the merits and then go that fraud was not practiced. On a reappreciation of the facts. On a reappreciation of the fact, on reconsideration of the materials, the Honorable Court could have held that.
Mr. Dave, how do you respond to this submission? That's the only submission.
Can I add one thing to what Manoj said? Manoj, in fact, I am for the first respondent, but the review petitioner is here. I'm the second person. Please see page 18. This is the fundamental error the High Court is. Your office will find his citizen out of the judgment sought to be read. Page 18, paragraph 33. Paragraph 33, starting the subsequent judgment of this court in Ram Prakash Agarwal. Further clarifies the law on the use of power under section 151 CPC in cases of fraud and holds as follows. Please come over the page, quoting paragraph 19 of that judgment. In view of the above law, the law on this issue stands crystallized to the effect that the inherent powers enshrined under section 141 can be exercised only when no remedy has been provided for in any other provision. In the event that a party has obtained a decree or order by playing a fraud upon the court, or where an order has been passed by mistake of court, the court may be justified in rectifying such mistake either by recalling the order or by passing any other appropriate order. That is the exception carved out. However, inherent powers cannot be used in conflict with other. There is no conflict here at all. The power of the court under 151 to recall an order on the ground of fraud is not in conflict with any other provision of the code. Manoj, after noticing that, the learned court, Manoj, his lordship should have merely said, we have gone through the facts. We do not feel this is a case of egregious fraud or fraud of the nature that justifies recalling. But that primary requirement was there. The jurisdictional fact for saying that 151 cannot be exercised is to say that we are not satisfied, not only saying that we are not satisfied with the fraud. The court could have also said, we are satisfied that the fraud is not of such a nature.
Let's hear Mr.
Some finding on the fraud was
Both points, both of you have made a similar point, really.
Yes.
That's the only point which we have to consider. What do you have to say?
Point to add, Manoj, which is that I appear for respondent number 3 in the present review petition. I was a party to the order of the High Court which found that there is fraud practiced upon the court. I was an applicant for it successfully, therefore, before the High Court. I was made a respondent in the civil appeal that was filed here by yeah. Yes, I was arguing in the SLP, but I was not served. So this order that is impugned in the review petition today, in which I am a respondent number 3, is passed without service to me.
The order of the High Court was filed on your IA.
Yes, and I see it. I am a respondent in the SLP. I am not served. The SLP is decided by the order which is now sought to be reviewed.
In the SLP.
I am therefore, that itself is a ground for recall of the order that is sought to.
That would be a procedural review.
We are swayed, if a party.
So the way, before you address the main submission on merits, Mr. Sibal argues that, though he was a respondent to the SLP, he was never served.
Served. Your Lordship will have to see that.
In fact,
according to us, he was served.
In fact, I filed a miscellaneous application bearing diary number 35752 of 22.
Your service now that I see the registry. Your Lordship will have to call.
Not served.
Where did you have his report?
He'll just check, he'll put the office report before us. In the meantime, then you can deal with the other two submissions.
Absolutely. No, I, of course,
as soon as he flags the office report, we'll put it to both the sides.
I'm adopting the submissions made by her.
Yes, Mr. Dave.
About 7 years after the decree has been made, the application is moved in the High Court. 7 years after. Now, your Lordships will have to see whether the persons who have moved that application, whether they have any right at all to move that application. But they have no interest in this land. They have played a fraud on the court. And they are now please turn to their application, which was filed before the High Court.
It is not a ground which has been taken by our court in this judgment.
If they are saying that fraud, there are two ways. Your Lordships, one is an easier way. Your Lordships may set aside this order and set down the appeals for hearing here. But if your Lordships are inclined to remand them to the court, then Lord, I am seriously prejudiced. I am entitled, Lord,
you're right.
Under law.
Not remanded back.
Yes.
What we will do is that we will recall the judgment,
yes,
place it before for fresh hearing.
That's fair.
And then
that's fair.
And
I will agree. Straight away.
Then sure, by consent can we set aside recall the judgment and restore the civil appeal?
Yes, certainly. Lordships may do.
Mr. It was complete on them. So anyway, that.
So let me just ask.
Sure.
But your Lordships may not fix it sometime.
Yes, absolutely.
After 8 weeks or so.
Yes.
Because it's very factual. And Lord, I'll tell you, Lord.
Ultimately, you may succeed by showing that, they are also guilty of fraud. They are saying that you are guilty.
Seriously guilty.
So that you can argue.
They have played fraud upon the High Court. They are playing a further fraud in moving this application, saying that we have right.
All right.
They have no right, Lord. I will show your Lordship, and they know it. To their knowledge, they have no right. Because they are not claiming from one Mr. Ganesh Gadial, who has no interest in this land.
That can be argued because that will have to be heard by
It's a very serious issue.
Now, you are appearing for R1, right?
No, yes.
You are appearing for My Palace Mutually Aided Cooperative Society. Mr. Sibal.
I am
Mr. Sibal, you are up for pro forma
Respondent 3 minutes.
R3 and you are for R2.
Lord, would you ask to work for?
You just wait for a minute, so that, because then a parthead will begin. That's all. All right. Somebody wants.
Pass the client. What they are hearing before. I don't want to face the what.
R2, who was the applicant, R1 in the SLP.
2 o'clock notice.
That is okay. Dictate a short order actually. In the meantime, that is.
Since I am accepting that.
Oh, they have come.
Don't embarrass me.
No,
I am
they are.
officer of the court. I also have my limitations.
Your client is come.
And while we do that, I just want to point out the only reason I made that submission was that we were not served.
Very well.
All right. The petition for review.
Your Lordship did not give reason.
All right.
Just say parties agree.
Yeah. During the course of the hearing of the petition for review, it has been agreed as between the learned counsel. Uske pehle appearances note kar lo. Mr. Vigiri.
Lord, I agree for the review petition.
Learned Senior Counsel appears on behalf of the review petitioners. Stop. Mr. Dushan Dave, Learned Senior Counsel, appears on behalf of the first respondent, which was who is the appellant to the
original appellant.
The original appellant in Civil Appeal number 5784 of 2022, which was allowed by the judgment and order dated 23 August 2022. Full stop. Mr. Sibal appears on behalf of.
I'm on 2.
Mr. Arima Sundaram, Learned Senior Counsel, appears on behalf of the second respondent, while Mr. Sibal appears on behalf of the third respondent. Full stop. Both the second and the third respondent have supported the case of the appellant. Next.
Of the petition.
Of the review petitioners. Party.
Though I can do with their support.
Mr. Dushan Dave, Learned Senior Counsel, appearing on behalf of the first respondent, states that by consent, the judgment and order dated.
Fairly states.
Fairly states. All 23rd August 2022.
But the subsequent length should know.
Maybe recalled without the expression of any opinion by this court on the merits of the rival submissions. Full stop. Learned Counsel appearing on behalf of the review petitioners and for the second and third respondents to the review petition have no objection to this course of action. Full stop. Accordingly, the judgment dated 23 August 2022 shall stand recalled. Civil Appeal number 5784 of 2022 is restored to file and shall be placed by the registry before a bench to be nominated by the Chief Justice.
There is an urgency on the
expeditiously in the month of February. In the month of February 2025. Full stop. The review petitions accordingly allowed in the by the order if I recall. Myself.
Sorry?
The special leave petition is restored. It's the original, the special leave petition is restored to file.
No, civil appeal.
Civil appeal.
Leave granted. But leave has been leave was granted by this order.
He was granted by the order which.
Therefore, my learned brother pointed out that it would be appropriate to the special leave petition.
The civil appeal, it has to be restored.
What your lordships may say in the on any
on a non-miscellaneous day. On a non-miscellaneous day.
Wait. Did you?
Well, that's rightly said, but it's SLP.
Yes, sir, that's what we have said.
I was just nothing.
Your lordships may say that no, in the meanwhile, proceedings before the High Court will remain stay. Otherwise, what there will be the SLP will become infringed. Parties do not agree.
That we always.
Both sides can agree.
No, but what proceedings?
Whatever you want to, High Court may.
There are miscellaneous proceedings which have been generated. Other
Was a stay.
not personal to them. Was there a stay?
Lordship. No, this. Your otherwise.
That you can move the court at the approach. All right, item.
Grateful.
No, the only reason I made that submission regarding service was service WhatsApp,
Sorry.
other, etc.
All right.
Nothing turns on it now.
All
Nothing turns on. Right.
Yes. Lord, there are some fresh matters.
Oh. This is your Unitech IAs, right? You'll have to issue notice on them or?
Something direction, because after your lordship has passed the order, work is happening there. So suddenly we find them all, simply occupying the whole place. Lordship may see the photograph and the IA. We just forgot when this court has very specifically, please say that two IAs for.
We'll say that if any, in the event that any obstruction is faced in complying with the orders of this court, the board of directors, the government appointed board can move the competent authority.
Which we have done. We have written to the police.
And necessary assistance shall be given. That's all that we have to say.
But 24/3/2021 order.
We'll say the grievance of the government appointed board of Unitech Limited is that obstructions have been faced at site in complying with the orders passed by this court, facilitating further progress. Full stop. We clarify that in the event that the work is impeded in an unlawful manner by any third party, it will be open to the government appointed board of Unitech Limited to seek police assistance, and all such assistance shall be made available so as to enforce the orders of this court. Yeah, that's all that we need to say. 33.
33.
32, I have already an idea, Your Lordship. 108720.
That is not on board today. When we take up Unitech next, we will take up your IA. Today was only some IAs were here of the government appointed board. Yes, 33.
But I had these for purposes beyond of efficiency or pisciculture.
Yes.
That means beyond, it was for 30 years when we came to the Navy, about 3-4 years ago. But the lease provides that it can be removed on consent of parties. I applied for renewal. But the file was processed. Ultimately, after approval that it should be done, it has been split into two. half has been restored to me and half to somebody else. For no valid reason, Lord, why this half has been given away to somebody where I have for 30 years created, Lord, fish ponds over, Lord, 600 hectares of land, spending crores of rupees with manpower. And when, Lord, things were right, because much time was lost in various orders, including orders of this court of CR, etc. It has been split into half. Lord, your Lordship says the minister's order, which is splitting it, Lord, towards the
They said that it's governed by the state government's policy of 23rd of November 2001, which requires consent from the principal lessee, namely DCKL, the Development Corporation of Konkan Limited.
They said not do it half. Give me half and give it to somebody else. Lord, if I am not good, I don't get anything. But if I am good, why should you split it when I have to be by Lord the blood, sweat and
Where is the vested right really in your
Lord, the treaty provides that it can be extended subject to mutual consent. I have an expectation, Lord, that I will.
But it's by mutual consent. You have no vested right.
I understand, but not. They have extended in other cases. So
not a case for our interpretation. Thank you.
Choose none.
No, Mr. We'll
You
close.
will get better fish and crop.
No, we're not interfere. Thank you. Item 34.
Develop plan, develop fisheries and crop.
Yes. Item 34. This is an interlocutory order of the division bench.
Serious impact because
The single allowed the petitioner and appointed an ombudsman to govern the affairs of the Bihar Cricket Association.
Critical thing that when allowing the petition, the single judge says, how can you have a quid pro quo like this? The vice president and the joint secretary.
But get your appeal heard by the division bench.
Can I just make one
Yes.
suggestion? The vice president and the joint secretary of the Cricket Association appoints the selection committee. The selection committee appoints the vice president and joint secretary's sons as members of the team in the camp. So it's a clear, obvious conflict. So the court says, look, there is a clear quid pro quo. We are not happy with how the ombudsman has functioned. We appoint a new ombudsman and we are frowning on these two people being selectors. The new ombudsman says, how is it that after the single judge's order, you have constituted a new selection committee with the same two people again in direct violation of the single judge's order? And they have now selected a team, Madrasa. The division bench says whether your petition is maintainable because it's an internal affair within the BCA is the question that arises, and therefore they stay the entirety of the judgment.
Matter is now posted for 2nd of December.
We have a match now with the new. Can I just complete? We have a match coming up on the 26th of October with this new team. I mean, this is going on. The poor Bihar cricket is not properly represented at all, and it's been going on for years.
But can the court really intervene in these matters?
We shouldn't have. Once a single judge has given a proper judgment, how can you stay the entirety?
Should the single judge have entertained the petition? Because these are purely private associations and a petition under 226 is filed.
For better or worse.
And the single judge then sort of passes orders.
One member of this bench who was a part of that.
I did hear it that
it's a public function.
Michael's not nailed them.
It's a clear public function. Article 226 lies. From 2004,
Anyways, what we'll do, Mr. Shankar Narayan.
Yes,
the division bench is seized of the matter. They have posted it to the 2nd of December.
Maintainability. But in the meanwhile, at least clarify this much, that the ombudsman will continue. A new ombudsman.
No, not ombudsman.
I'm sorry. Yes. The ombudsman's order has not been stayed. The ombudsman's finding has not been challenged. The ombudsman's order has been challenged. 4th October 2024, which is at page 273. Just see that for just a minute. So former High Court judge, he has taken notice of this at page 274.
And he starts functioning from the other website of the rival association.
This apart, second sentence at the top of page 274. This apart, out of the 3 selectors, 2 were the same whose appointments were earlier made by the Committee of Management, and those selectors had appointed kith and kin of the then Vice President and Joint Secretary, which were deprecated by the Honorable High Court in para 67 of the judgment said so and so. And such the High Court had made a specific direction that a fresh selection of selectors
You
may
may
be made.
pursue your proceedings before the division bench, that's all.
This order has to stand.
Proceedings in the appeal.
This is why children leave these states and go to other states to play, because when you appoint your own president's son, joint secretary's son, I mean, that is so glaring. How can
But that was earlier
your lordship give
committee
this
that
a blessing?
suspended, elections are held.
Proceedings are still pending. The proceedings in the appeal are still pending before the division bench of the Patna High Court, and are due to come up on 2 December 2024.
Yes.
Hence, at this stage, we are not inclined to entertain the petition under Article 136 of the Constitution.
All grounds are
all the grounds, the petitioners are left are at liberty to pursue the proceedings as respondents to the appeal on all grounds available in
I'm
grateful to us.
35. You are given a seat in the stay round. There's a specific policy that you can't now change. If a candidate is allotted a seat in the stay round, they must join the allotted seat college. Failure to join the allotted seat will result in the candidate being debarred from the NEET examination for 1 year.
Yes, sir. There was inordinate and unexplained delay in issuance of notice for third one by a state.
Now you've been given something else.
Yes.
It was
And this is the reason.
seat in the stay round. Now you can't suddenly say no. I'll undo the whole process.
The state round came on 27 September. And result of
High Court is right, sir.
9.
It's governed by the policy. High Court is right. They followed the policy.
But also, there was no part on the part of the petitioner.
Thank you. We now write the pen. 36. Yes, yesterday's part. Yes, Mr. Natraj.
Just take one minute on this UGC issue, which was troubling them.
Yes.
That's the only thing I want to say. I will also talk about the UGC. I have a very short submission. Have a look at the section.
Yes.
According to me, Lord, there is no conflict between the grant of degree under the Act and the UGC Act, which was troubling the court towards the end of yesterday.
Yes.
Kindly will not see the section 22 of the UGC Act. It is at page 82.
Shall be exercised only by a university established or incorporated by or under a central act, a provincial act, or a state act.
So now, my lord, just turn to the section for a second. This, my lord, Act is in pursuance of NT 66, my lord, subject to 66. So 25 is subject to 66. That's how this comes in. Now, my lord, have a look at the section for a minute. My lord, have the section.
Yes.
The right of conferring degrees shall be exercised only by university established in central act, provincial, state act, or a deemed university, etc. Sale is provided, please read that. Now come to 3. 3 is the key. For purposes of this section, degree means which degree referred to in 1. Degree means such degrees as with the prudence and government which is specified in the Gazette. So degree is specified in the Gazette will only be issued by those which are under 22(1). I am not professing to issue a degree which is specified in the schedule. I am issuing my own for whatever its value.
And it's nobody's case that these degrees which the State Act allows us to confer are referred to in the schedule to the UGC.
I know.
We got the point.
Correct. So simple thing is,
we'll put it. We got the point. We'll put it to, yes. But if you're giving a BA, which would probably be in the UGC Act schedule, or an LLB, that would not be permissible.
Correct. Absolutely correct.
But if this particular degree is not specified in the schedule,
absolutely correct. So, what I am
we'll request the ASG to give us a clarification. Yes,
that the degrees which I give after 12th class, which is 12th class is by a board, which gives you a certificate, like a higher secondary certificate. After that, if you want to study without PG or undergrad, those degrees are called without Fazil and Kamil. Those are without undergrad and PG, granted by the same madrasa, which is without teaching up to 12th. We don't have school and college. It will go up without in the same madrasa. And these degrees are given to those who wish to continue higher studies in our medium of education, and essentially, my lord, is an essential qualification of teachers in the madrasa. So if a student wishes to teach in the madrasa, he must get these. It is only for our in-house purposes that people take these degrees. They do not take these degrees, as my lord the Chief Justice said, well, I've got a BA, should I get into LLB? You can't get into LLB. I don't profess to grant you that.
Your point really is therefore that if it is not a degree as defined in subsection 3, then the prohibition under 22(1) doesn't
apply. So that's one. Now the second point, bro. Your Lordship may see Article 28. The second point.
Yes.
The second point which I am raising is, kindly turn to 28. In 28, Milord, your Lordship finds 28(1), Milord, proscribes, it's an injunction. No religious institution shall be provided, instruction shall be provided. So instructions are not to be given. We start with this. Instructions are not certain religious,
but you are not providing instruction at all.
No, so I'm not on that. Now come to 2. Nothing in 1 which is administered by the state shall apply to an institution administered by the state, etc., etc. So, Milord, 2 is an exception to 1. 1 says no religious instruction, but 2 says you can have religious instruction provided you fulfill the requirements of 2. Am I clear, Milord? So, religious instruction can be provided if you are an institution administered by the state, but under an endowment and trust, which we have. So, we can have religious instruction. Now, come to 3. Now 3 says, Milord.
No compulsion.
Now, if somebody wishes to, Milord, get imparted religious instruction, he can do so voluntarily without compulsion under 3 under my school. The point I am raising is the High Court now says your school will be closed. Right? Students will go to normal schools. If you go to a normal school, I will not, Milord, voluntarily have the right guaranteed under 3, namely to get religious instruction. Therefore, the order of the High Court, Milord, is flawed by virtue of 28(3), because it is forcing every student and parent to go to a normal school where he will not get religious instruction even if he wants it.
You're not appearing for them, but the Madrasa board is not really in that sense administered. It's not an institution, education institution administered by the state. It's a pure regulatory body. So 2 would not really come into the picture at all.
What happens below the student? There are 50 lakh students in these colleges or schools who are now to be adjusted in normal schools in the state of UP. So if a father and a student says, I wanted religious instruction, which I was getting hitherto before under subclause 3 in a madrasa, say in Waringal or Bihar or wherever. Now by a forcible shifting by the fiat of the High Court, I will not get this in the normal school, and therefore my right under 28(3) will be violated. That's the point I am raising, Milord, on behalf of a large number of students who will like to, Milord, have religious instruction, who want to be steeped, Milord, in the traditions of the
28(1), yeah, right. 28(1) is an absolute bar where the institution is wholly maintained out of state funds. If an institution is wholly maintained out of state funds, 28(1) says no religious instruction whatsoever will be provided at all.
Correct.
28(2) lifts that bar to a certain extent in respect of an institution. Now 28(3) refers to institutions which are either recognized by the state or receiving aid out of state funds. But 28(3) will not cover a 28(1) situation which is wholly maintained by the state. Now, if an institution is partly receiving funds from the state, or because 28(3) doesn't use the expression wholly maintained out of state fund, it says receiving aid. And 28(3) also says recognized by the state. What 28(3) does is, it says you will not compel any student to. So if a student wants to voluntarily receive that is protected by 28(3).
Milord, that a student getting, Milord, voluntarily a religious instruction under subclause 3 school, let me call it subclause 3 school, if he is getting voluntarily with consent of his father, this will be taken away by the mandate.
What 28(3) does is that 28(3) recognizes that religious instruction may be provided in a school which is either recognized by the state or which is maintained by the state. But What it says is that you cannot compel any student to.
Which also means not the other side of the coin is if I want, I can have.
Obviously.
So if I wanted.
Absolute bar is in 28(1).
I'm only saying, Lord, I wanted it. Some student wanted it with his parent consent.
Now, by the direction to relocate these students, they lose that. We got your point.
So you have, Lord, effaced. The High Court's order has effaced 28(3). And as I said, Lord, your Lordship, sir,
We got the point, yes.
the third is a bullet, one line point. Lord, this petition was filed by an advocate. He has no connection with this act.
Looks like there were a bunch of petitions before the High Court.
Main is by the advocate.
Yes.
The writ petition was by a singular advocate. He, my Lord, has no connection with the Madrasa Act. By minds, it is not treated as a PIL because then it has to go to the PIL bench. And then, my Lord, your Lordship's prescription in Chaufel's case. But once in Chaufel, has to apply to see, my Lord, whether a PIL should be maintained.
As a matter of fact, how many petitions were there before the High Court?
Lord, what I have is the main judgment, my Lord, is in Anshuman Singh Rathore, writ number 6049 of 23. This is not by a I read the petition. I am a lawyer. Doesn't even say what is the interest. I am a lawyer, and therefore it is not secular. Therefore the act goes. But you must have some concern. It's going on for 100 years. Our your Lordship, remember, my Lord in Allahabad, there was Muir College. Muir College was then converted to Allahabad University. It had two branches there. But I don't have time, I would have shown you, so I deleted a note. It had two branches, Lord. One was Sanskrit, Lord, department, and one was Farsi and Lord Arabic. That is how, Lord, the branches spread. That became, Lord, the university, and we carried on. So prior to this act, there were non-statutory guidelines. For the last 100 years, people are studying in these schools for whatever purpose. Lord, you can't force somebody to say, Lord, this is, I would say, Lord, to be secular. Should be to allow what the sweep of 25 to 28 do. The judgment is not secular.
Secularism really means live and let live.
Then the High Court says no, to live it the way I mean the normal school.
Mr. Natarajan, deal with the point. Yes, Mr. Chan. Yes, Mr.
One page your Lordship will know at volume 3A, page 760, is the written statement filed by respondent number 3, the state of UP, the counter at it.
Because the counter supported the validity of the act.
The counter said the petitioner has no locus. What is being taught are modern subjects. What is being imparted is secular education. I will not read it, it's a 9-page counter. It is from page 760, volume 3A. And this is on affidavit.
Yes. Yes, Mr. Natarajan. Same part.
Yes. Our position is, in a sense, actually it is our legislation which has been struck down by the High Court. Where we defended, we filed a counter. However, when the Constitutional Court struck down this particular legislation, we have not filed any further SL in this particular proceeding challenging that order. Then first thing that on facts, I would like to raise it. So therefore, without getting much into other aspects, just I would like to touch upon the legal aspects and the defending legislation.
But as a state,
we are defending it.
You are defending the legislation. So we take it, therefore you are on this side. Are you with the other side?
Depending on what is there in the legislation, and to the beyond that, I do not want to go in this matter because we defended our legislation. We filed a counter, but however, when the Constitutional Court struck down the act, we accepted it, and we did not file any SLP. That is the.
You're not filing an SLP is one aspect, but when especially petitions filed by someone who challenges the judgment of the Allahabad High Court striking down the validity of the Madrasa Act, which you have enacted,
yes.
Are you therefore standing by the validity of your act? Because it's an act enacted by
the state.
It's an act of the state.
Act of the state.
So do we record that therefore you support the validity of the act and that you stand by the counter which you filed in the High Court?
Can't go beyond that.
State of UP, right?
State. the act has been struck down by the High Court, and which the Constitutional Court struck down, which has been accepted by not filing the SLP. That is the present position in this matter. Now,
now that a bunch of SLPs have been filed by people who are challenging the validity, the correctness of the judgment of the Allahabad High Court, your stand as the government of UP is that you stand by your act.
find a counter before the High Court. We have to find a counter. We can't deviate from what as a state. We can't so keep on changing depending upon.
Then we have to hear Guru. Then we have to hear Guru on this.
But before that, from our side, any further regarding legal issues which arise in this matter?
Mr. Natraj, as a state, you have wide powers under the Act, under Section 20 and 20, to ensure that the basic quality of education is maintained even in the madrasa. Nobody denies you that power. In fact, that power has been expressly conferred on you by the statute. If you find that the quality of education is not what the state, as a matter of public policy, expects of all students who are undergoing education, in which case nobody deprives you of those powers. In fact, that was the ground on which you defended the Act, saying that, look, I as a state have sufficient powers to intervene in a situation where I feel the interests of education are not being adequately preserved. Therefore, don't strike down the Act, because I have sufficient powers as the state. That's what you argued before the High Court.
Yes, that's what I wanted to point out. A legislation can be struck down on two grounds. No third ground is available. One is the competence. This is not the case of competence.
Fundamental rights. Also could be third ground, any other constitution, like Article 286.
Yes, that's the third one. Here, entire scheme of the Act will have to be examined only in the context of Part 3, nothing else. It is not the case of legislative competence or violation of any other constitutional provision. It would be followed under Part 3. For that purpose, the entire Act need not be struck down. What can be the examination would be some provision, particularly if it offends Part 3, then to that extent that can be examined. Striking down of the Act would be basically on 3 grounds. Earlier in Bennett and Coleman, although they said only 2 grounds, no third ground is available, but subsequently your third ground is also accepted. But this is not the case of legislative competence, nor the case of violation of any other constitutional provision, but the case of only violation of some of the fundamental rights, for which the entire legislation need not be struck down. And what would be permissible is to examine some of the provisions whether it offends the constitutional provision or not. Will have to be examined, especially in the light of the rest of the provisions being regulatory in nature.
Yes.
Therefore, some of the provisions which are contained in the particular provision, although they have pointed out with regard to the syllabus from 1 to 4, then 7 to 10, 10 to 12, if I am required to, let me point out the syllabus, how it is that they have been taken and how they are either consistent or inconsistent with either the SCRT, that is State Education Board syllabus, and also the further syllabus where the certificates are required to be issued. And in one of the, from the 10th to 12th, there is a government order which has been issued to recognize them as equivalent to the 10th and 12th certificates. The certificates issued at 10th and 12th have been treated to be equivalent to other equivalent courses under the mainstream.
By government order?
Yes, by government order. Yes.
Which is that government order?
There's a government order which Volume 3 R.
Page?
Page 13. Volume 3 R.
1-3?
Yes. 3 is paragraph, page number 30.
Thank you.
Page 13
of volume 3R.
Right?
Yeah, just below that. Para starts with the 18 and the para 19. The syllabus for class 18 is as follows. The para starts.
So what document are you reading, Mr.
Our counter of the.
Oh, this is your counter.
Counter.
All right.
Yes, where we are.
Yes.
The main file.
Volume 3R. 3R volume.
3R.
3R. That's in the submissions compilation. The syllabus for class 9 and 10 is as follows. Compulsory Diniyat, Arabic literature, Persian literature, Urdu literature, English, Hindi. Optional subject, any one subject from maths, home science, maths, social science, science, medical science.
The certificates offered by the Madrasa board at the high school level are Munshi, Persian language, and Maulvi, Arabic language, and the intermediate level is Ali. The state government has granted equivalence to these certificates with the so and so dated 95 to the high school level and intermediate level respectively. Government of India has also granted equivalence so and so, that is 2010. So, in respect of two courses, the equivalence certificate is required to be issued. We have treated as equivalent to the mainstream.
This a little further, elaborate this a little further.
Yeah.
That means that if a student has studied in this madrasa, he has cleared 10th and 12th, and a certificate is issued. He may decide not to pursue further studies with the same institute. So he is entitled to seek admission in BA, BCom, BSc as the case may be. That's what you are trying to drive at.
That's one part.
Okay.
By issuing such an equivalence, the further avenues in different disciplines may do.
So he need not obtain a certificate from a secondary education board of the state or higher secondary education board of the state so far as 12th.
Treated as equivalent.
Equivalent.
You can take a BA or BSc or BCom.
Subject to other recognitions under the.
Correct.
Whatever it is.
Any of these students who have passed the Munshi Maulvi appear for the NEET, for instance?
I don't think, because it's a separate regulation.
That NEET will be governed by a central regulation.
But then thereafter.
Because there you have to have PCM or PCB or whatever.
Subjects are not.
They actually go to the National Institute for Open Schooling. They clear their 10th and 12th under the NIOF and lot many, and they've all gone thereafter. Oh, I see. What should we do? NIOF. Would everybody have it?
Yes. However, when it comes to degree and PG courses, where Qasir and Fazil are concerned, no equivalence has been granted.
Now, what do you have to say to Mr. Rohaggi's argument on the interpretation? Actually, I thought you were appearing for the Union of India, but now we'll require your assistance in that. What Mr. Rohaggi argued today was that 22(1) prohibits anyone who gives a degree from granting a degree unless it is a university within the meaning of the statute. Now he says degrees for the purpose of subsection 3 are those which are defined in a notification issued by the UGC. So the prohibition in 1 is that unless you are a university, you cannot give a degree. He says that degree is that which is defined in by a notification of the UGC. Unless this is contained in a notification of the UGC, the prohibition in 1 does not apply.
Yes. There is some conflict which I wanted to point out with respect to.
But you can deal with it separately. You can conclude this part and then at the end we'd like to hear you on that.
Now, in respect of degree and PGs are concerned, there are 2 provisions under the Act. That's section 9 and 20 of the Act, which specifically says they are degrees and diplomas. That may be little inconsistent with the provisions of the UGC Act.
Where do you, can we
then go to section 9 and 20?
Where is the Act?
Regulations.
Regulations.
Yes, 4A. Volume 4A, section 9 and 20. Yes. Page 37. And regulation 20. These are 2 regulations. Kind of have a look at it.
Section 9A.
No, 9. Regulation 9.
Regulation. No, this we are dealing now. We are reading section 9A.
Functions of the board.
Right. That is not regulation. That's a statute. To prescribe course of instructions, textbooks, other books and instruction material.
Yes. Functions of the board, section 9.
Or we look at only at Kamil, puzzle and other courses.
Yes. Subject to other provisions of this Act, the board shall have the following functions, namely, to prescribe course of instruction, textbooks, other books and instructions, materials, if any, Pradhanya, Patwanya, Munshi, Pomolvi, so and so. To prescribe the course books, other books of instruction, material of courses, RB, so and so.
We have to deal with only A, insofar as it deals with Kamil and Puzzle.
Kindly come down to E. To grant degrees, diplomas, certificates, or other academic distinctions to persons who have so and so, so and so, so and so. That is the one provision which confers the power on the board as a part of its function to grant degrees, diplomas, certificates, and other programs. Then kindly go to section 20 at page number 40. Power of the board to make regulations.
Yes.
The board may make a regulation for carrying out the purpose of this Act, in particular and without prejudice to the legality of the foregoing provisions. The board may make a regulation providing for any or following of the matters, namely constitutional power and so and so. Then D, courses of study to be laid on for all degrees, diplomas, and certificates. Then further E, conditions under which candidates shall be admitted to the examinations and the research program of the board and shall be eligible for degrees, diplomas, and certificates. And
so what is the submission, Mr. Natarajan?
Submission 1 or 2 provisions, the statutory provisions provides for conferring degrees and diplomas. If you go by the strict interpretation of the expression degree, then it should be only as recognized by the UGC as being the only body which is authorized to.
But which part of the UGC Act?
It's part of the UGC Act.
Which provision of the UGC Act?
UGC Act.
Now see section 22.
Yes.
ये upload कर दीजिए. Just see section 22. It's on the screen.
Correct. Yes. 22. Right to confer degrees. The right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act, a provincial act, or a state act, or an institution deemed to be university under section 3, or an institution specially empowered by an act of parliament to confer or grant degrees. Save as provided in subsection 1, no person authority shall confer or grant or hold himself or himself as entitled to confer or grant any degree. For the purpose of this section, degree means any such degree as may, with the previous approval of the central government, be specified in its behalf by the commission by notification in the official gazette. So, under this act, the degree has to be construed or taken as a degree which is recognized by the particular statute under the UGC Act. Here, the meaning which is under section 20, although it is under legislation, it is expressed as a degree that cannot partake the character of the degree which is recognized under the UGC. That is one provision which may have.
No, but if you see it's 22.3, yes. What 22.3 says that for the 22.1 first, correct, says a degree can be conferred only by a university, correct, established under or incorporated in a central act, absolutely, state act, or a deemed university under section 3. Only 3. Yes. Now, but what is meant by the expression degree? Yes. 22.3 says degree means a degree which is specified in a notification issued by the UGC. Correct. Once it is specified in a UGC notification, yes, nobody else except a university can. Correct. And this is not a university. The Madrasa board is not a university. Absolutely. But is this particular degree which they give specified in any notification issued by the UGC?
No, I don't.
Then the bar under 22.1 doesn't apply.
They can't. This degree cannot be actually. This cannot be.
No, it's against you.
Yes. This cannot be construed as a degree as such.
No. उसको समझ नहीं आ रहा.
BA has to come. BA in UGC, it's a separate notification by UGC. The latest notification.
Notification of UGC?
UGC, I'm told, with respect to this Fazil and Government, there is a 2014 notification.
By UGC?
Yes, yes. I'm told this is some.
Where is that?
I'm trying to share.
You have that notification, Guru?
They're just sharing it.
UGC के लिए कौन अपेयर होता है? नरेश कौशिक अपेयर होते हैं क्या? कौन अपेयर होता है UGC के लिए normally? वो हैं.
Or else, as it is the expression under the State Act, that the degree or diplomas and the power to confer such degrees, that may run inconsistent with the UGC Act and the regulations.
This Fazil and Kamil, yes, is specified in a notification issued by the UGC. The moment it is issued, it's covered by a notification. Right. No question about it. Then the bar under 1 applies.
That's right.
We only want to know as to whether UGC has issued such a notification. Bhai, dekh lo, wo kaun hai applies. Who appears for UGC normally in our court? Anybody here who knows? Sarupama, you have a notification? What does it say? Is Fazil Kamil in there?
No, not that big, but the BA, etc. More deeply with that terminology is there, which is.
Just not sharing.
But is this Fazil or Kamil, Sarupma, is that referred to in a notification of the UGC?
As much I see,
Who appears for UGC normally? I mean, not Naresh Kaushik, na? They'll clarify, they'll just talk to the Secretary of UGC and tell us in 2 minutes. Who appears? He's always here in our court.
My turn comes on this point also.
Yeah, but let's also have somebody from UGC specifically,
My expert, I would assist.
All right, you assist her. But we'll ask a factual clarification from the UGC lawyer. कौन है भाई UGC के लिए? एक ये करो ना, standing counsel for the UGC is request to be present in the court.
My lords, may I read just one specification of degrees with Urdu, Persian, Arabic nomenclature, serial number 126 Fazil, 127 Afzal Ulma, 128 Kamil, 129 Mumtazul Tafsir, Mumtazul.
What are you reading out?
My lord, the notification of 2014 by.
Oh, it includes. That's what I was asking all this while. Where do we get that notification on the record? No, is it in the? Sarupama, is it in the?
Prepared this and I would assist my lord in my term.
All right. There's fair enough. There is a notification by UGC. All right, got the point. एक बार notification होगा तो कोई सवाल ही नहीं आएगा. Right. Mr. Chidambaram, once there is a notification issued by Gulshan, thoda niche baitha. Once there is a notification, then we are within the fold of 22-1.
Not updated list of notification.
Oh.
This is only dated 1989.
You know, Ms. Swarupama Chaturvedi, who is appearing for the National Commission, she seems to have a notification of 2014. Why don't you email that to Mr. Stalekar? To Mr. Stalekar, so that they will also get it. All right. So that then everybody can see it.
And as officer of the court, I would also.
No, thank you.
So Manoj Sinha is notified, obviously.
Then there is a. It's there, right? There is a 2014 notification.
Mr. Manoj Sinha is standing counsel for you.
Manoj Sinha, yes.
Get it. I'll inform you. Thank you.
All right. What else, Mr.
Then when it comes to subjects in 1 to.
Just 1 second. This now we've got Swarupama. This 5th July notification. Brother Mishra was saying, let's take it at the worst, that they are conferring a certificate or even a degree which is not authorized by the Act. Surely that can't result in annulling the Act.
That's what the entire Act could not have been struck down. At the most, some provisions, if it offends either some other Act or.
All right, what else, Mr.
Then with regard to 1 to 7, the syllabus, how it has been, what are the syllabus that has been taught or prescribed by the board. They are available at volume 3A from page number 889. The 1 to 5 are called Tatania.
389.
Yes, it starts from 889 at volume 3A. And relevant page will be 892.
3A, right?
Yes, 3A.
889.
Yes, starts from 889. And the relevant page will be the table we get at page number 892. That's for 1 to 5, which is called Tatania.
Yes.
Then from 6 to 8, which is called Hokania, which is available at page number 894. Then Maulvi, where the equivalence has been granted, where they are required to choose one optional subject of maths or home science, logic, or social science or science or that's available at page number 898. At 903, yes, traditional subjects that become optional. Only one subject is required to be taken.
So this specifies the books and the syllabus for 1 to 6.
Yes.
Then it also specifies the books and syllabus thereafter at page 898 for secondary, that is Munshi Maulvi.
In different levels.
And then it goes on to the subsequent levels. Then senior secondary, which is Alim, 905.
That's at 905.
And then it goes on further.
Yes. Now, one aspect, the subjects which are now taught or prescribed by the board in these courses, that's especially 1 to 5 and 5 to 6 to 8, may have to be examined or really considered in the light of Article 21A. Which is right to education, where the state is required to provide free and compulsory education.
At the primary level.
At the primary level. Whether it satisfies or whether it's more desirable to have the courses which are otherwise accepted by the regular board or the modern subjects which are required to be taught as the mainstream for the purpose of promoting the education in the country. So, in the light of Article 21A, the right to education has been brought, no doubt. The madrasas and the Veda Pathashalas are kept out of the purview of the Act. Kindly have a look at the provisions of the Act. That is Right of Children to Free and Compulsory Education Act 2009. That's volume 4A, page number 45.
is subject to Articles 29 and 30.
Correct.
No, but it says, look at 1.5. Nothing contained in this act shall apply to madrasas, Vedic pathshalas, and educational institutions.
Primarily imparting religious instruction.
So RT Act then doesn't apply to.
Kept out of the purview of the Act. However, the underlying principle under Article 21, which has been recognized as a fundamental right, which has been interpreted by this Honorable Court in two judgments, the need to promote the quality education, which means not concerned, not in particular to the traditional or this kind of syllabus.
But independent of the RTE Act,
yes,
the Madrasa Act itself confers a power on the state government to issue directions under 20. And the state government can yet exercise that authority to effectuate the right under 21.
That can be done. Therefore, the regulations power has been given to the board also to frame certain regulations, and where the power is conferred upon the state, retained with the state also to issue appropriate directions.
1.5 of the Right to Education Act. Nothing contained in this act
shall apply to madrasas, Vedic pathshalas, and education institutions primarily imparting religious instruction.
Primarily imparting religious
Instructions are kept out of the purview of the Act.
I was a different question.
Yes.
The words primarily imparting religious instruction, does it qualify only education institutions or also madrasas and Vedic pathshalas?
Everything. That's what we do.
Was all, then the exemption in 1.5, does it apply only to the matters of religious instruction and the act will apply to other matters?
The focus is imparting religious instruction under 1.5. The focus is made on by saying that imparting religious instructions, which are madrasas, Vedic pathshalas.
So what happens when a madrasa imparts secular education? Will the act apply to that?
If they are going with the secular, that they are not exempted.
Science, civics, history, English, Hindi.
Then there is no exemption. Because the emphasis on nothing contained in this act shall apply to madrasas, Vedic pathshalas, and educational institutions. Then primarily imparting religious instructions apply to all three. Let us take the Vedic pathshala, especially giving only the religious instructions, where you need not follow the provisions of Party Act. Or any other educational institution which is imparting only religious instruction are kept out of the purview of the Act. If it is secular, then this exemption may not apply. As it is, the RT Act should be made up. The expression is also very clear. It's a primarily imparting. Yes. Yes. Then section 4 also very clear, subject to provisions of Article 29 and 30 of the Constitution, provision of this Act shall apply conferment of rights on children and free of so and so and so. That is especially only for the limited purpose of where they are required to provide the admission and all those things in the education institutions, either established or administered.
Yes.
Now, independent of this RT Act, the primary object of Article 51A, which has been
Yes.
independently that has been considered by some report in two judgments, the need where the subjects are required to be prescribed, which should provide avenue for better education, quality education.
What is the judgment?
Yes. One is 1992, Volume 3, SCC 666. I could not get the neutral citation.
And
the next one is 2012, Volume 9, SCC 310. I mailed it, Mr. Harry. I made email to the
Mr. Chidambaram, Mr. Khurshid and Mr. Patwale, have you looked at our digital SCR or have you accessed our digital XCR, which is the digital SCR? No. Please do have a look at the digital XCR because we've, our SCR was wholly out of date. We have now updated it. It's in a digital form. You have page flip options, so it's like a regular SCR now.
We do that CC online.
But do have a look at the digital SCR. It's the flagship project of the Supreme Court. The official report is now up to date completely with head notes and everything. Do please spend 5 minutes in the evening and look at it. In fact, in a matter where Mr. Arvind Datar was appearing, he suggested that we make some improvements in it. So our team has immediately got down to it and is working on those additional facilities which Mr. Datar said we should incorporate to make it more user-friendly. I have a dedicated team of people who are working in the Center for Research and in the library. Yes.
Before getting that one factual aspect, in 2017, you have amended, the regulation has been amended, which is at page number 153 in volume 4A, where you have prescribed teaching of all subjects can be imparted, but the
volume 4A page
153.
1 second, let's see that.
Yes. Where under modern subjects are allowed to be taught in these. Amended in 2017. It's available at page number 153 of volume 4A.
See.
Yes. 2017 amendment. Yes. The amendment starts from page number 148. The relevant page would be 153, bottom. General conditions after recognition. Hmm? 2016.
in response to my lord's question on the RTE provision, where we read.
It says the Act will not apply to madrasas, Vedic pathshalas, and any other institution primarily imparting religious instruction.
In the Lok Sabha debates, there was a clarification by the minister when about the language, and the minister then clarifies. We are just sending it to your court master as well, my lords. The minister clarifies that since many madrasas do not offer religious instruction, that's the interpretation to that clause. So it is educational institutions who provide religious instructions. That's the third category. There is an understanding that madrasas may not be providing religious instruction.
In which case RT will apply to them.
They are exempted from RTE despite being institutions that do not provide religious instructions. That's the understanding of it. We'll just share it with your.
The third category is disjuncted and other institutions providing religious.
Other educational institutions who provide religious.
We'll just require, Mr. Chidambaram and Mr. Khushi just assist us on that 1.5 little, after 5 minutes. You can just maybe look at it and then assist us on that.
And we'll share the Lok Sabha debates.
Yeah, you can do it. Yes, Ms. Nataraj, what else now?
2016 regulations, the modern education is allowed to be taught, which is available, which I was pointing.
Which is the relevant part?
Relevant part is at page number 153, just above 150, page 154, last column. That is the column number H.
Teaching of all subjects can be imparted.
Yes.
But the medium should be Urdu, Arabic, and Persian. Yes.
Independent of Article 21A, even before it was introduced as a fundamental right, this Honorable Court in the Mohini Jain's case, kindly have a look at it with regard to primary education itself. What should be the approach? Has been
Mohini Jain?
Para 9, 12, 13, 14.
Right.
Kindly have a look.
And what about 9, 12?
Yes, 9, 12, 13 and 14. Maybe.
Yes.
Para 9. The directive principles which are fundamental in the governance of the country cannot be isolated from the fundamental.
That's okay, we've read that. Let's see 12.
Yes. Then para 12.
Right to life.
Right to life is the competitive expression of all those rights which the courts must enforce because they are basic to the.
Para 14.
Yes. Then para 14. Right to education, therefore, is a concomitant to the fundamental rights enshrined in Part 3 of the Constitution. The state is under constitutional mandate to provide education institution at all levels for the benefit of the citizens. The education institution must function to the best advantage of the citizens. Opportunity to acquire education cannot be confined to the richer section.
All right, we got that. Yes.
That is one. The next one is after that is in 2012, volume 9, SCC 310.
Para?
Paras 21 to 24, 4 paras. Especially the quality of primary education and the.
Para 21, the cover?
Yes. Thus, in view of the above, it is evident that imparting elementary and basic education is a constitutional obligation.
Knowledge and wisdom so that one can lead a better life.
Acquire knowledge and wisdom so that many lead to better life and become a better citizen so to serve the nation. Then para 22. The policy framework behind education in India is enshrined in the belief that the values, equality, social justice, so and so, then satisfactory quality of children education. Then 23. Every generation looks up the next generation.
Because 21A only embodied primary education as a fundamental right.
Even otherwise it was independently considered to be a fundamental right. And
so what is the submission now that you
compulsory education which has been now brought in as a fundamental right, even otherwise it was read as a part of the constitutional right, that has to be given a actual meaning. It should be meaningful. The right conferred upon the students or children to acquire the proper knowledge about the worldly affairs or the modern education.
And therefore, even dehorse the RTA Act.
Yes.
The state can regulate.
It can. And it is desirable also to give modern education and prescribed by the academic experts.
Right.
From these angles, some of these provisions may fail examine. My last submission would be the striking down of the entire act was not at all correct. Only some provisions at the most could have been examined in the light of the constitutional right of the parties. And still states.
You have to say two things.
Is given to 560 madrasas on facts by way of grant in aid.
You have said that in the counter?
Yeah.
Now, are they wholly maintained out of state funds or partial aid?
Salary grant.
Salary grants. Anything else?
Yes, that's all. Because beyond that, I do not want to. It's what the.
We will hear you now.
And what is the direction as a state?
Half an hour we'll give you to, because the whole gamut has been covered, but your perspective now we'll hear, and then we'll hear Swarupama.
Also substantially has argued really in
What
favor
you
of validity. Substantially. So we really have to be present the other side.
Dear Lordship, permission. Your Lordship, item 9, when it will be taken away, it is challenging the restitution of conjugal rights.
We are going to start marital rape immediately. The marital rape in exception to section 375.
Yes.
That is part third. This will be taken up right after this matter.
Oblige, Your Lordship.
Separately. Right. Yes, Guru. Mr. Sinha, yes. Mr. Sinha, we just want your assistance. You are not a party to this proceeding, UGC. You know, section 22(1) of the UGC Act says no person can award a degree unless it is a university established by a central act, state act, deemed university. And 22(3) says degree shall mean such degrees as are notified by the, you know it by heart, 2014. Right. Now there is a 2014 notification specifying Fazil, Kamil and all these, degrees. So that means there is a notification. So no person other than a university can award degrees. That's a very clear position.
Yes.
We just wanted to check, maybe if you talk to the Secretary UGC or something, is there any further up-to-date notification? Because the Learned Council who are appearing, they're researching and giving us all that data. You are the official source of it. So just ask them, following that 2014 notification,
To my knowledge, no.
there's none. But just check once and you can tell us before we rise that if there's some other notification. They'll tell you offhand whether there is any other notification. Thank you so much.
May I just one small point?
We'll also record that we had requested you to render assistance, so you can tell your client also that I was requested by the court to assist the court. We'll record your appearance also. Thank you.
There's a constitution bench decision, a 5-judge bench.
Yashpal?
No, Manoj, this is Pramati Educational and
Yes.
which exempts all minority institutions, aided and unaided, from the purview of RT and the rationale as to one.
Oh, which is that?
This is Pramati
For what?
Educational and Cultural Trust. 2014 8 SCC, page 1.
2014?
8 SCC, page 1.
Volume 5A? Para?
Para 55 minutes.
Udhar dikhaiye. They'll just see it. All right. Oh yeah, we have it here. So volume 5A, right?
We may just mark para 55 in that.
ये कहाँ गया 36 में था ना
Speaking for the bench. Para 46 onwards, my lords. And this speaks to the rationale of, neighborhood principle otherwise would apply. This might dilute the nature of the institution, so on and so forth. And there is one other reason, my lords, which emerges from the rules. What the RT also does is it burdens in terms of salaries of the teachers, etc. So it increases the costs of the institution.
Said that to the RT Act, to the extent to which it applied to minorities, was ultra vires.
Yes. And aided and unaided minors. And actually, minors, I had appeared in this defending the RT, so it's quite.
Did they refer specifically to madrasas or something? No.
No, minors, not specifically.
So they said that basically the Act does not apply to minorities at all. Minority, linguistic and religious minority.
Aided as well as unaided.
All right.
Because Manoj, that would then change the character of the institution. That's the. It's para 46. The bench says, inasmuch as the RT is applicable to minority schools referred to in clause 1 of Article 30 of the Constitution, this would be ultra vires. Para 46, man.
Right. Yes, thank you. Yes, yes, Guru.
Broadly, 4 points I want to manage.
Yes.
One, the Madrasa Act purports not only to regulate Malots, but more fundamentally recognize what is essentially religious instructions. The scheme of the Act is such that Malots, what is otherwise not secular education is given the imprimatur of state recognition. Therefore, Malots, it's unconstitutional. That's the first submission I'll be making. The second submission will be the
But how do you, but all right, you formulate.
Make my broad submission.
The invocation?
The invocation of or the confirmation of Article 30, right, into Malots, the Act, into the construction of the Act is not sustainable. Because Article 30, right, which is distinct in character, still entitles the state Malots to prescribe standards of secular education for maintaining quality of education. In other words, Malots, Article 30 is not a carte blanche to provide any kind of education, particularly Malots, religious education, which is essentially bordering on instructions.
Right, that's second.
Third point, the expression, the entry, found in entry 25 this 3. Namely, education laws has to be understood as taking reference to making provision for and recognition of secular education. By reason of legislative practice and second Malots constitutional bench definition as to how an entry has been. In fact, Malots, please recall judgments like Gannon Dankali and then Gashi substances.
So which will be the entry pertaining to religious education within Pathshala?
Nothing specifically, 25 talks of education.
So you mean to go to entry 97?
Perhaps, but in list
education, when it says education, it will mean religious education also.
This one, 66 is there about higher education.
Yes.
25 in list 3 is education subject to Malots.
Absolutely.
66.
Coordination and determination of standards and institutions of higher education. We are not referring to higher education.
I'm talking about entry 25 in list 3. I'll make you my submission once.
All right. And 4 and 4.
Fourth Malots is with reference to the UGC Act. How Malots?
What's the formulation?
The formulation is this. The Madrasa Act, to the extent it purports to award degrees and other recognition of higher education would be Malots unsustainable by reason of operation of UGC Act.
Would be in conflict, we'll say, with section 22.
A central law.
Section 22.
20. Conflict with the UGC Act.
I think the last point, you need not labor too much because, there is now a notification, which is very clear.
I don't need to really.
And they've also made almost a tacit concession. We'll decide it, but.
I understand. Very good. I got the first point. Now, please come to the Act itself.
But you are saying that it basically regulates religious instruction.
That's it. No, more than, in fact, the burden I saw is this. The Act is not, as I said in my combination, not merely regulating.
But why is, assuming that it regulates religious instructions, why is it unconstitutional?
For the simple reason was, the Act singles out chooses religious instructions provided by one particular community and gives the states recognition for such education, which is why it will offend.
But religious instruction is like religious instruction is necessarily in relation to a particular community.
No, correct. Therefore,
education may be in relation to religious philosophy.
Absolutely, and that's the specific case I'm finding. The argument of the petitioners that the Act is only a regulatory act in respect to submission is not so. The Act more fundamentally recognizes this form of education. I think this fundamental point in respect to submission has been missed. But for this Act, my lords, education of this character.
What character you are talking about?
Religious character.
What do you understand by religious instructions?
Religious instructions is when you are basically taught tenets of a particular religion, rituals, and everything connected to that.
From where do you get this?
No, my lords, there are two. One, I show from the syllabus itself. From the syllabus, and the manner in which the Act is worded, and case law laws which draw the distinction between religious education and religious instruction.
Well, Aruna Roy's case.
Aruna Roy is there, and then the earlier judgments also, DAV is there. Aruna Roy, in fact, draws upon the DAV also. I've seen that also. Please not come to the Act. Please have a look at the Act. An important facet of the Act.
That is page 33, no?
Yeah, that's right. Volume 40. Now, please come to, first of all, the definitions at 35. 2H. May I read that? Madrasa, right at the top. 2H. Madrasa education means education in Arabic, Urdu, Persian, Islamic studies, tilt logic, philosophy, and includes such other branches of learning as may be specified by the board from time to time. Now I'm pausing for a minute, Lords. Such other branches of learning as may be specified by the board from time to time necessarily relate, Lords, only to the earlier parts, more so for one important reason. There are already in existence two separate boards for secular education. In the state of UP. In state of UP, there is one board belongs for primary and secondary education. Then there is another for intermediate education. So this is essentially belongs for Madrasa education. This is the first point. Then please go further. Constitutional board. The provision has been set out in great detail by the petitioner's counsel. I will not read it again. The submission that I am making is predominantly consisting of persons who are educated in one form of religious education. That's the predominant character and flavor of the board. Then please go to section 9, page 37, the functions of the board. Now, A itself, to prescribe courses of instruction, textbooks, other books and instructional material, if any, for Qur'ania, Fokania, Munshi, Maulvi, Alam, Kalam, Fazil and other courses. Again, Lords, one particular stream of education. Next, B, prescribe the course books, other books and instructional material of courses of Arabic, Urdu and Farsi for classes of high school and intermediate standard in accordance with the course determined by the Board of High School and Intermediate Education. Prepare the manuscript for the course books, instructional material, etc., etc. Now, then, my lords, please see F to conduct examination of the Munshi, Maulvi, Alim, and of Qalim and Fazil courses. G is important notes. To recognize institutions for the purpose of its examination.
Right.
This is my respectful submission. Perhaps the purport and the impact of this is something which will have to be given special focus in this submission. Because this is the provision. This is the provision by and under which a stream of education of this type is now recognized by the state.
But look, whether you recognize it by the state or otherwise,
yes,
you cannot exclude the historical and socio-cultural context
yes,
that in India,
yes,
we do have religious instruction. Whether it is in the Vedas, whether it is in the Quran, whether it is Vedic Pathshalas, whether it is Madrasas.
yes.
Now, if a statute enacted by Parliament or a statute enacted by the state legislature seeks to regulate it to ensure that while you are training young people, young minds, you must train them in a manner which is conducive to the quality of education, the broader national interest. What's wrong about Parliament or the state legislature recognizing it?
It's a twofold.
I'll give you another example. You have different, I just called for the act. You have different systems of medicine in India. All right? Allopathy is not the main, not necessarily even the mainstream. You have Ayurveda, which is predominantly associated, with the history of the Hindu religious practice and scientific practice. You have Siddha, you have homeopathy, you have Unani, right? Unani is specifically associated with it has a Persian origin. Now, suppose Parliament seeks to regulate all these branches of medicine. Now, while regulating these branches of medicine, Parliament is entitled to ensure that even in a Unani college, you must observe certain standards. You must pay your teachers the minimum salaries. You must have proper and transparent recruitment of teachers. Your students must pass a basic entrance examination. It's always open to the legislature to do that as a matter for regulating that area so it doesn't operate to the wider detriment of the community.
Now, there is no denial of the fact that there are these traditional methods of learning. The two levels that I'm talking about in terms of approach to a law of the nature of this. The state really concerns itself to recognize the law of secular education. And the purpose of such secular education and the state maintaining and regulating the standards is to ensure the laws that the persons who qualify and come out are persons who are fit to and able to participate in the democratic process and are able to be part of the mainstream of living.
But that will also apply to the state regulating religious instruction as well.
No.
Because when you are educating young people, the state has a vital interest in ensuring that these people, when they leave the institutions, are worthy citizens of the nation. Therefore, you must provide them basic training in different arts, different sciences, so on and so forth.
That's the second level at which I want to respond.
And second, remember,
Yes.
the Constitution in Article 28(3) recognizes religious instruction.
Correct.
And that's not susceptible to the basic structure argument because it's in the original Constitution.
It is not. But then, in Xavier's law, there is a square discussion on 28(3) and what state can do to ensure that 28(3) doesn't handle to provide only religious instructions. I'll show that part. I'll show that part. That's the second part of what I mentioned. At two levels, I said. One is the state being concerned with secular education to ensure that there is quality maintained. The second part of it, very important, is this. The state really has to ensure that the persons who come out of these institutions are persons at par with the others in terms of people who get the other stream, the regular stream of education. Otherwise, you have a system, for example, persons who come out of class 10 and 12 from this stream of education, they will be able to compete for collegiate education. It will not require a minute to decipher the position that they will not be able to compete with most of the other people who get regular education for most of the courses which are offered to study. That's why we must see Act is something which has to be understood in its true perspective. That is why I said this is not an act which merely regulates some activity. I hope I'm making it clear on that. You say somebody coming out of class 10 from this stream, who will go into class 12, who wants to go into class 11 and 12 of regular stream of education. That's one class of people. The second class of people are those who go on from 10th to 11th and 12th to the same stream of education. Thereafter, their aspiration to go to the regular stream of education from this college onwards, from collegiate education onwards. In either case, the state clarified saying a lot of equivalence is recognized. The question I asked is this: are they in a position to be at par with persons who otherwise receive regular stream of education? The obvious answer is no. And here I want to point out towards the syllabus which is provided for. A lot of arguments are raised by counsel from the other side, focusing on the syllabus part of it. But the final print, if I may say so, has been missed in that. Please come to that. Please come to the syllabus.
But assuming, therefore, at the highest, what is your submission? That the syllabus is not adequately secular.
Absolutely.
Right?
Absolutely.
But does that invalidate the act?
No,
the state government has a power. Look at the state government's wide powers. Under 13, the state government has the power to address the board with reference to any work conducted or done by the board, and to communicate to the board its views on any matter with which the board is concerned.
There again, if I may, I understood the purpose of what is calling from.
Then the state government can issue directions to the board under section 13.
There are two things there again. One, and this is a primary point to be considered in lots of respect to submission. The Act, when it sets out laws with function, does not mandate that the board shall ensure that secular education is provided. That's very important in respect to submission. The Act does not contain such a mandate. That's very important. That's the first point. Second point, I hope I've made myself clear on this.
Is it your argument that all those students who decide to undertake education in these institutions, it is detrimental to their interest, and that why are they being deprived of the education at par with other students? Is it your argument?
The second part, yes, the answer is definitely. The first part belongs whether it is detrimental to them is very simple. Ultimately, that is something belongs is for the individual student, and in fact, the age is such that they don't really have an agency. That's really something where the parents or the guardians take a decision. Therefore, for the two facets of the question which come from my law, the second part, my answer is an affirmative yes. The first part, the answer is no, that is something which is subjective. Whether it's detrimental for them or they want to pursue certain stream of education and thereafter go into certain avocation or activity.
And look at the salutary purpose of the act.
Answer that.
Look at the salutary purpose of the act.
Yes.
Suppose the act was not there, that these madrasas are not recognized, right? Those who complete, say, the first 10 or 12 years of education are not recognized as having any valid employable qualification which recognition brings.
Yes.
That doesn't outlaw the madrasas. The madrasas will still continue to exist. Okay, all right, through the length and breadth of the state of Uttar Pradesh. But these children who go to the madrasas will have no recognition at all. Is this really in the national interest?
That's right.
Or is it in the national interest that you regulate the madrasas so that you can mainstream these children? Ultimately, these children will find employment. They will go into national open schools, so on and so forth. You can't just wish away several hundred years of history of the nation like this.
No, I understand.
You know, the idea of the act is that, look, suppose we we uphold the judgment of the Allahabad High Court. This act is unconstitutional. What happens? Parents who are going to send their children to the madrasas will send them to the madrasas, bereft of any regulation. We must make it clear, we are not at all contesting the power of the state to prescribe regulations, the power of the state to prescribe rules, which the state must do. That's why it's a salutary power which was given. But if there is no regulation, this will be just a sort of it will be a silo into itself without any legislative intervention or executive intervention.
The point that I want to highlight is this.
Therefore, this is a policy. It's a policy statement in the Act that look, rather than leaving these madrasas completely unregulated, we recognize them, but we subject them to conditions.
That's
right. And whether the state government thus far since 2004 has properly exercised its power of regulation is a different thing. A particular state government may feel, look, we need to have a more proactive approach. See, the state government is given the regulations have to be framed by the board with the previous approval of the state government. So there again, the state government is a very vital role. You will not approve these regulations if I find that, as a state government, these are contrary to the interests of the welfare of the children. Rule-making power is not even invested with the board. It's an exclusive power of the state government. State government can frame rules.
Look, my problem is something more fundamental. I was just pointing out. There is no mandate in that statute laws for secular education to be directed to be provided. That's where the Act, my lord, falls foul of the constitutional scheme. My lord spoke about the instance of my lord, the chief justice mentioned a statute of this nature. What will happen to these madrasas, the people educated in these madrasas? They will just come out without any kind of mainstreaming, and they will not be able to be part of next mainstreaming.
The students.
Now see 9B. Prescribe 9B. No, in response to what you said, see 9B.
Yes.
Prescribe the course books,
yes, correct.
other books,
yes,
and instruction material of courses
correct.
of Arabic, Urdu, and Farsi
yes.
for classes up to high school
yes,
and intermediate standard in accordance with the course determined therefore by the Board of High School and Intermediate Education.
Yes.
So even when you are prescribing the course books, the idea must be that there must be parity with what the Board of High School and Intermediate Education.
That's what I'm repeatedly saying. The Act, if I may say so.
Of course, of courses of Arabic, Urdu and Farsi is very broad. It can also refer to where Arabic, Urdu and Farsi are used as medium of instruction, not necessarily only the subject of instruction.
Let me proceed on such an expansive basis. The point which I am endeavoring to make before my notes in my discussion still standing. Namely, that the Act does not mandate anything of this nature. Now, two.
That you point me.
That's one. Number two, what in fact is provided as syllabus and course content, I dare say, my lords, is only a sprinkling of secular education. That I'll show from the syllabus. And that, my lords, flows from the operation of each statute within it, with all its force.
Your second point really doesn't impress us for this reason, that if the actual syllabus which is provided by the Madrasa board gives only a sprinkling of religious instruction, secular education.
Yes.
The vice does not lie in the Act, but the remedy lies in the power of the state government.
There, my lord, I respectfully submit. A provision like section 13, what my lord the Chief Justice is repeatedly pointing out, that will have to be understood in the light of the overall scheme of the Act, my lords. The primary provisions, my lords, being the definition of Madrasa education, the constitution of the board, the functions of the board, because they really constitute the backbone of the Act. In the light of that scheme, the directions of the state become relevant and they have to be understood and construed in the light of that. The Act does not purport to recognize Madrasa institutions to be capable of providing education which can ensure that persons become part of mainstream. That's the real problem with this Act. If I may resubmit on this, because this is really
the Act does not mandate secular education.
Act does not mandate one, and I think this is central to my submission of the validity of that. The Act has not been made and has not been designed in a manner to ensure that persons
undertaking this course of education or stream of education can be mainstreamed. And there lies the fallacy. And there lies the unsustainability of the act. May I come to the syllabus now, sir?
No, but assuming you're right, we take your word for it. We have also seen the syllabus that it's basically on the theology and a little bit of, optional subjects are science, etc. We've seen that.
Other nuance to it, factual nuance to it, which in my respect,
That you've seen. But then the point is the government has to step in when the regulations are submitted or issue a direction under 20. What is the government doing?
No, there, my lord, I'm asking myself this question. My lord, the Chief Justice raised a very important question. What will happen to these madrasas and the person studying in this institution minus this act? That this act is not there at all. Please forget, my lord, keep washing, setting aside the act in High Court. Such an act is not there at all. What is the resultant position, my lord? If it's an institution which can avail of Article 30, they go before the concerned board and ask for recognition. They can still have the recognition if they have sufficient secular content in their same theological courses. And they'll get the affirmation. And the students can still be part of mainstream. Therefore, my lords, I hope I made myself clear on that. Yeah. Therefore, it is not that with the setting aside of this law, madrasas are put in peril. No. In fact, my lords, the stream of education which is sought to be provided, which is not ensuring quality, that, in my respectful submission, is fomented by an act of this nature. The act, rather than ensuring, my lords, that the quality is improved or changed, really results in a status quo, perpetuation of status quo, or even increasing, my lords, the maladies or the problems with that kind of education.
All right, we consider that, yes. What else is the
Then,
point?
lords, please see this syllabus for a minute. The factual nuance I wanted to highlight was this.
Syllabus we have seen. Yeah, we have seen that syllabus. In the morning we saw it. In fact, right from 5th, 6th, it's predominantly you can take it. We'll take your word for it.
Just one more word on that. The important point is, from 8th standard onwards, which is when they really start getting into the mainstream, there, my lords, 5 subjects, you take one of them as optional. Therefore, only one subject out of 5.
That point was really not, my lords, brought into focus by the petition.
So your grievance is with the syllabus.
Not just that, my lords, not just that. The syllabus is a continuation and an implementation of the provisions of the Act and the ethos of the Act.
All right, that you made your point.
Therefore, my lords, from 8 onwards, you are in a position where the secular content of, my lords, the education is confined to only one subject out of 5, and that too optional. That's where, my lords, the problem gets aggravated. Therefore, just to complete this point, my lords, of this loop.
Ultimately, we have to also have a look at the broad sweep of the country.
Yes.
Religious instruction is not something which is unique only to the Muslims.
No, my lords, it's not.
You have religious instructions among the Christians, you have it among the Jews, you have among the Hindus,
Sikhs, everybody.
The Sikhs. And it's a country which is a melting pot of cultures, civilizations, religions. Let's preserve it that way.
For a minute, I cannot, my lords, take.
In fact, the answer to ghettoization is to mainstream, is to allow people to come together. Otherwise, what you'll essentially be doing is putting people in a silo, to be shunted and forgotten.
There, my lords, in my respectful submission, the Act doesn't really aid in mainstreaming. That's really the burden of the strong. The Act definitely does not mainstream them, and that is why I'm saying, my lords, the Act is something which is not. What is falling from my lord the Chief Justice, I bow down, my lords, nobody can take exception to this lofty approach. The point is, does the Act help that? With the Act going away, my lords, Madrasa education does not go. It is just that it will have to be then following certain standards.
It will be unregulated.
No, my lords.
If you seek affiliation with the CBSE or the Board of Secondary Education in UP, then of course the Board of Secondary Education will say, well, these are the subjects and that's all that you can teach. So Madrasa will become like any other school then.
Then how do you give effect to this definition?
Now, please now see the light of this. I am obliged to my lords for this question.
Just come to volume 5A for 2 minutes. Apropos what has fallen from my Lord the Chief Justice.
Yes, 5A.
5A and come to PDF 2465.
2465.
Read this paragraph from
Aruna.
Read it.
I'll
read it. This is exactly what has fallen from my Lord the Chief Justice.
No, I understand.
Read it. The expression.
The previous page.
Placitum CDE. That's 2.
The expression.
It's 5.
I'll read that.
Volume 5A.
I have that with me.
Yeah.
That is the paragraph.
So keep 2 things in mind.
Yes.
Keep the definition of the term madrasa education. 9.2, what has been pointed out. Now read this.
I'll read that.
Read it.
That is the para starting with the expression.
Correct.
I'll read that once.
Yes.
The expression religious instructions.
Slowly.
I'll read. The expression religious instructions used in Article 28(1) has a restricted meaning. It conveys that teaching of customs, ways of worship, practices or rituals cannot be allowed in educational institutions wholly maintained out of state funds.
Stop here. This is where this idea of secular education comes. Correct? Now further proceed. But
Article 28(1) cannot be read as prohibiting study of different religions existing in India and outside India.
Correct.
If that prohibition is read with the word religious instructions, study of philosophy, which is necessary based on study of religions, would be impermissible. That would amount to denying children a right to understand their own religion and religions of others with whom they are living in India.
With whom they are living in India and with whom they may like to live and interact.
Correct.
Study of religions, therefore, is not prohibited by the Constitution, and the constitutional provisions should not be read so.
Otherwise, the chances of spiritual growth of human being, which is considered to be the highest goal of human existence, would be totally frustrated.
Now read this part. Any interpretation of Article 28(1), which negates the fundamental right of a child or a person to get education of different religions of the country and outside the country and of his own religion would be destructive of his fundamental right of receiving information,
deriving
knowledge.
and conducting his life on the basis of philosophy of his life. Absolutely not. There is no quarrel about Manoj, this.
Then your argument that they are being deprived to get into the mainstream fails.
No, there. That's why I said, Manoj, I carefully said the first part of my Lord's query as to whether they are being deprived of certain education. I said that's something entirely subjective. That's entirely subjective.
See, look at, for instance, how are Buddhist monks trained?
Yes.
They are trained up, they're taken in at a very early age, and then thereafter, they are trained to be Buddhist monks. Now, in a given case, the legislature may intervene and say that, well, you should also provide some element of secular education to these young kids.
Yes.
Kids, because they join at the age of 5, 6, 7 or whatever, and then they continue until now. That's the ethos of the nation.
Correct, Manoj, correct.
Whether it's, remember what you are arguing in the context of Islam will apply across religions today in India. This argument will apply across, from Veda Pathshalas to institutions training Buddhist monks, to the Jain schools, which are all generating young.
Absolutely, Manoj. I'm alive to the positions. I am only on this limited point as to what the purport of this act is, where a particular line of education, stream of education of a particular community is sought to be given recognition, state aid and assistance without ensuring certain content of secular education, which helps in mainstreaming.
But that we can take care of by interpreting the act, particularly the provisions of the statute, which allow the state government to intervene and say that, yes, you have a vital interest, please go and intervene if you want. That's none of our business. But the state, which will really take care. I mean, we share your concern as well. There's no doubt about it. I mean, please don't it's not that we are, sidelining or belittling what you are doing. We share your concern that, well, we have to ensure that these children are worthy citizens. How can you be a worthy citizen if you can't speak more than one language, or you don't know math, or you don't know science? Everybody is not going to be a religious teacher. At the age of 15, 16, some child may say, I'm not interested in religion. I want to be a shopkeeper.
Absolutely.
So I should be able to at least do my accounting, right? So, therefore, basic minimum standards have to be maintained. The state does have a vital interest even in ensuring standards in places of religious instruction. And we will interpret it in that way.
No, I follow.
But to throw out the act is to throw the baby out with the bathwater.
No, there is one other portion in the light of what went from my Lord, this is Pardiwala and Aruna Roy. There is one other question in Aruna Roy, but before that,
But you just see the question which was put by Pandit Lakshmikanta Maitra in the Constituent Assembly.
Yes.
May I put the honorable member one question?
Yes.
There is, for instance, an educational institution wholly managed by the government, like the Sanskrit College, Calcutta. There the Vedas are taught, Smritis are taught, the Gita is taught, the Upanishads are taught. Similarly, in several parts of Bengal, there are Sanskrit institutions where instructions in these subjects are given. You provide in Article 22(1) that no religious instruction can be given by an institution wholly maintained out of state funds. These are absolutely maintained by state funds. My point is, would it be interpreted that the teaching of Vedas or Smritis or Shastras or Upanishads comes within the meaning of a religious instruction? In that case, all the institutions will have to be closed down. Now just go down last. Just see how Dr. B.R. Ambedkar answered.
My own view.
The above relevant part, that is Placitum D at page 2467.
That's right.
The above relevant part of the constitutional debates, this is a finding of the Supreme Court.
Yes, that's true.
The above relevant part of the constitutional debates and the concluding remark of Dr. B.R. Ambedkar give an indication of the minds of the framers of the Constitution. They had seen the distinction between religious instruction as mentioned in clauses 1, 2, and 3 of Article 28 and study of religion. or religious education as a philosophical
And
study?
you know, just above that, Mr. H.V. Kamat's question, on a point of clarification, does my friend Dr. Ambedkar contend that in schools run by a community exclusively for pupils of that community only, religious education should not be compulsory? The Honorable Dr. B.R. Ambedkar, it is left to them. It is left to the community to make it compulsory or not. All that we do is to lay down that community will not have the right to make it compulsory for children of communities which do not belong to the community which runs the school. That's what that's the principle of 28.
I board on, my lords, what we are placing for my lords' kind consideration would not run foul of this broad, this salutary approach which my lords have taken.
But you got your point. Your point. It's secular education one.
Correct.
In fact, the purport of the Act is to provide religious instruction.
Exactly, to the
And third,
yes,
therefore, the syllabus, which is virtually nothing in secular education, is nothing but the alter ego of the Act, and therefore it is unconstitutional.
That Sanskrit college mentioned in that debate, my lord.
Yeah, we saw
the
it. My
university-
learned brother showed it.
University, fully aided university, functional as it was pre-independence.
Now, my lords, I want to show one or two portions, my lords, something was shown from Xavier's by my friend Mr. Sanchar. Please see the other part in Xavier's. In fact, that perhaps will answer a part of what fell into my lords is Pardiwala also. In fact, just to complete that loop, my lords, that last part which my lord read.
Actually, this court went to the extent of saying,
yes,
Article 28(1) therefore does not prohibit introduction of study of religions
correct, my lords,
in the state educational institutions,
go down,
including those wholly or partly aided by the states.
True.
As a matter of fact, study of religions has been considered necessary for the unity and integrity of India.
True, it's true. Pluralism of this country, which is unique to this country, my lords, is maintained that way. That is recognized.
Composed of people of various religions and faiths, they are expected not only to live together and tolerate each other, but to live a harmonious life in peace and love.
Absolutely, absolutely. What I'm respectfully submitting is this, my lords, what we are placing for my lords. I want to show one more portion in Aruna Roy, my lords. May I come to my lords, page 2458, same judgment, Aruna Roy. The concurring opinion of Justice Dharmadhikari, my lords, read from the latter part. Please see the earlier part where it starts.
Yes.
2458, my lords, got that. The last sentence, the para starting with the last sentence, the first sentence in that last paragraph. Secularism is the last line there.
Yes.
May I read that much? Secularism is the basic structure of the Constitution. Clause 1 of Article 28 prohibits imparting religious instructions in education institutions fully maintained out of state funds. The case of BAB College versus State of Punjab has been noted. The words religious instructions have been held as not prohibiting education of religions dissociated from tenets, rituals, observances, ceremonies, and modes of worship of a particular sect or denomination. The academic study of teaching and the philosophy of any great saints such as Kabir, Guru Nanak, and Mahabir was held not to be prohibited by 28(1) of the Constitution. A distinction thus has been made between imparting religious instructions, that is, teachings of rituals, observances, customs, and traditions, and other non-essential observances or modes of worship and religions, and teaching of philosophies of religions with more emphasis on study of essential moral and spiritual thoughts contained in various religions. there is a very thin dividing line between imparting of instructions and study of religions. Special care has to be taken of avoiding possibility of imparting religious instructions in the name of education or study of religions. And then, my lords, the latter part, what fell from my lords, what we read. So this is something, my lords, which has to be carefully sort of sifted, my lords, when we deal with religious education. And this is the point which we want to place for my lords' consideration as a matter of working of the statute.
All right. I think now we've made quite a lot of headway on this point. What is the next point?
Now, on the state interest for, my lords, ensuring secular education. Now, please come to Xavier. Same volume, my lords, page 388.
Page 388.
Yes. In fact, it's part of, my lords, Justice Matthew's opinion, starting at page 382.
Yes.
I'm just placing it for the record, my lords. And the question that's being considered by them, I'll just read that. My lords don't need to go to 82. I'll go back to 88 to read it. I'll just read the question at 382. That's where the opinion starts. The first question that arises for consideration in WP number so-and-so is whether Article 31 of the Constitution confers on religious and linguistic minorities only the right to establish and administer education institutions for conserving their language, script, or culture, or whether the scope of the guarantee under that article is wide enough to enable them to establish and administer any other education institutions of their choice. Now, there, my lords, they go into 31, the submissions of the petitioners, the submission to the Union of India through the ASG. Now, please come straight away to 388.
This question doesn't arise.
Now, in fact, this last paragraph, the last paragraph in 388, my lords, was placed by Mr. Shamshad. I'm reading the previous paragraph in 388 after the extract. May I place that, my lords? The state cannot insist that the children belonging to the religious minority community should be educated in state-maintained educational institutions or in educational institutions conducted by the majority. The state's interest in education, so far as religious minorities are concerned, would be served sufficiently, please note this, my lords, by reliance on secular education accompanied by optional religious training in minority schools and colleges. If the secular education is conducted there according to the prescribed curriculum and standard, Article 28(3) implies that a religious minority administering an educational institution imparting general secular education has the liberty to provide for religious education in the institution. The continued willingness to rely on colleges conducted by religious or linguistic minorities for imparting secular education strongly suggests that a wide segment of informed opinion has found that these colleges do not do an acceptable job of providing secular education. The state concededly has power to regulate and control the education of its children, but it cannot by a general law compel attendance at public school or college, preclude attendance at the school or college established by the minority when the parents seek to secure the benefit of religious instruction not provided in public schools. The parents have the right to determine to which school or college their children should be sent for education. Now, they are pausing for a minute, my lords. Therefore, the state can insist that you have appropriate secular content. The rest of the optional religious training is really for the parents or the children, as the case may be. This is the... Yes, please.
389 PDF.
I'll do that.
In short,
yes,
secularism in the context of our constitution means only
an
attitude of leave and let leave, developing into the attitude of leave and help leave.
That's true.
That's secularism.
Absolutely, absolutely. Therefore, the focus, my lords, I want to make is on the state's vital interest in ensuring that these institutions have appropriate secular content. Now, please see how they further expatiate on this. Page 390, right at the top. 390.
So, what is the point that you're making?
The point I'm making is what the state has a vital interest and can ensure and should ensure that, my lords, education provided by minority institutions in excess of power under 30 should contain sufficient secular content. 390, can I read the first part, my lords? 390. The state's interest in secular education, I'm sorry,
The argument is also at page 389.
I'll read that, my lord. Which part my lord want me to read?
Come to 389.
Yes, my lord, I have.
The fundamental postulate of personal liberty excludes any power of the state to standardize and socialize its children
Yes.
by forcing them to attend public schools only.
Absolutely.
A child is not a mere creature of the state.
Yes.
Those who nurture him and direct his destiny have the right, coupled with high duty, to recognize and prepare him for additional obligations.
Absolutely. Absolutely. I bought on. Nobody can take any exception, my lords, to this formulation, wholesome formulation. I'm saying what I'm placing for my lord's consideration will not go against this. Will never militate against this. Now, please come to 390 for a minute at the top. The state's interest in secular education may be defined broadly as an interest in ensuring that children within its boundaries acquire a minimal level of competency and skills, as well as a minimum amount of information and knowledge in certain subjects. Without such skill and knowledge, individual will be at a severe disadvantage, both in participating in democratic self-government and in earning a living. No one can question the constitutional right of parents to satisfy their state-imposed obligation to educate their children by sending them to schools or colleges established and maintained and administered by their own religious minority, so long as these schools and colleges meet the standards established for secular education. That's all, my lords, I'm placing for my lords' consideration.
Okay.
Therefore, 30, my lords, is not something which is some kind of, my lords, a carte blanche or an overarching protection which will justify an act of this nature.
There are two postulates. One, religious instruction per se.
Yes.
Has historically and culturally never been an anathema in our society.
Yes.
We must accept the fact that religious instruction exists across communities.
True.
Two, once this two, even if it's an institution which is run by a religious or linguistic minority, the state can regulate the standards of education in the interest of ensuring the excellence of education. No difficulty about it. Third, the extent of the state control will vary upon the nature of the institution. For instance, in a case of an engineering college run by a minority institution or a medical college, the state will say, look, you can't have 90% religious instruction. You have to have proper secular education because they're going to become surgeons.
Correct.
But when the purpose is a religious institution, a religious instruction, then the state may be justified in saying that you must provide a basic minimum, not that overarching. So a secular education with, say, a CBSE school or any other state board school will provide. It will vary upon the nature of the context, really.
That's right. With the bottom line being, in my respectful submission, just to add to what went from my Lord Chief Justice, the bottom line being, it cannot be a case of primarily religious instructions with a sprinkling of secular education on.
I'm not sure you're right, actually, because it really depends on what you are producing out of that Pathshala.
No, that's why I'm saying, my lord, the approach is very simply this. Are we looking at a set of people who are getting educated there who will be at par with a mainstream student or a person?
Why do you want them to be at par?
No,
you can't compel them to be at par.
My lords, because this act purports to equalize them and place them there. 10 and 12, my lords, they are equalized and placed there. It's one thing, my lords, they want to pursue a separate parallel stream of existence and activities, totally different. Today, what you are trying to do is to really say that they will be part of the mainstream. That's one. Second thing, my lords, for the state to single out one particular stream of education of one particular community and say, I'm going to recognize this and I'm also going to aid this. Is this correct constitutional? These are the two submissions, my lord, for my lord can consider. And the next point, my lord, this is so far as the first two submissions are concerned. And third point is this, my lord, on education under entry 25.
Yes. So you are saying entry 25 should not include religious instruction.
I will just refer to my written submission. My lord can have a look at it.
You know,
Take the time.
entries in the legislative lists are supposed to be read in a very broad and comprehensive manner.
Correct. The basis for what I am submitting here is this, my lords. I go back to Gannon Dunkley, and then 2001 gaseous entry 25, I think 21 or something, and union list. The settled principle is any expression used in the constitution which has acquired a certain meaning in terms of legislative practice, the same meaning has to be given to it. Please recall Gannon Dunkley, Sale of Goods Act. Sale of goods found in entry 54 of list 2. State wanted to tax works contracts.
That's not a sale.
There's no sale. There was a constitutional amendment 366/2098 to bring in works contracts. Therefore, for that, my lords, therefore, I am referring to the Hunter Commission. Thereafter, my lords, the goods dispatches starting from my lords 18.
But in India, can we say that education has acquired a meaning which would not include religious education?
No, I'm saying, my lords,
it's an essentially religious country.
No, my lords, to recognize and, my lords, regulate only one form of what is essentially religious instructions. That's all I'm saying. State doing that is the point. There is one point which I'm repeatedly saying, and my apology for this one. Minus this act, minus the board, the absence of the board will not mean absence of madrasas. That's the most important point. It will not mean that this stream of education will cease. From
Education entry 25 has acquired a distinct connotation.
Yes.
To not include religious instruction.
Yes. In fact, we have filed written submissions, it has been emailed. Please make a note of page 10 onwards. In that, I don't want to read that, members can have a look at it. The history of handling of education in India during the British period, thereafter, from page 10 onwards, up to page 14. Government of India Act of 1919 have given one before that, the Hunter Commission, etc. Then the 1935 Act.
According to you, it really means only secular education. All right, we'll consider. We'll hear the other side on that. Thank you, Guru. Thank you so much. Thank you. Ms. Diwan?
Sorry, Manoj, I overshot the
No. You were making, therefore we also heard you.
You try and keep it as tight as possible. I'm responding number 8 in 78574. First and foremost, the entire purpose and design of the Act, because it lays such an overwhelming emphasis and in fact a disproportionate emphasis on not just religious instruction, but I would say a certain singular focus. It has a very singular focus, and that is at the cost of mainstream education. This is my point. So, my lords, the purpose and design, and I will refer to very few sections, I'm not going to take your lordships through them again, but the overwhelming emphasis is such that it eclipses mainstream education. Now, my lords, please bear in mind, these are not schools where it's not like a Sunday school or a catechism class where children are being sent for religious education, which parents are, my lords, are entitled to do for 3 hours a day, 4 hours a day, whatever they wish. But it cannot be at the cost of, my lords, elementary education as we understand under Article 21A. Now, Article 21A, my lords, makes a provision for free and compulsory education. Some meaning has to be given
to what is meant by compulsory education. Now, my lords, we have a right, of course, under, my lord, whether it's 25, 30, whichever provision, a right to an identity and a religious identity, very important. And of course, we are a very, very religious country. No difficulty with that. Those are very important rights, but not at the cost of mainstream education. That is the point. And I'm going to show that this act, my lords, as it stands, the essential character and essence of this act does not permit even the state under 13 or whichever provision, my lords, to go outside that essential basic character of the act. Now, my lords, when we talk of compulsory education, we meant I understand that the legislature meant a broad-based education. And your lordships have quite recently, my lords, in the child marriage judgment, your lordships have interpreted it as, of course, my lord, global engagement, openness. My lord, we cannot expect, yes, that in certain socio-economic, my lords, conditions, that everybody automatically gets a global engagement or such openness of mind. However, I think, my lords, under our constitutional scheme, the whole purpose of education was to enable children to break out of those birthmarks from where they began and where they were born, the socio-economic conditions, maybe the intellectual or the educational exposure of their parents. The idea is to get you out of that and to give you an opportunity. Then at the end of the day, you may choose not to do that, but it must give you an opportunity to grow out of where you came from. And what is happening here is much too early in the day, these children are being made to forego those rights without even understanding.
But you know, that broad argument cuts across religions, because I mean, there is, as you know, there is always a critique about religious instruction which is given to, say, young monks or young Batus, as we call them in Maharashtra.
Right.
At that age, you are making them undergo compulsory religious instruction. A child of 6 or 7, what understanding does the child have?
Yes.
Or, you know, you have the Jain sadhvis, for instance. So this,
Lord,
that's the wider social debate in the country.
Yes.
But you equally have to accept that that is India. I mean, you know, we can't gloss over the fact that that is India.
May I respond?
Where children young children are sent to these institutions. Maybe sometimes they are sent because, you know, the families want that child to have some protective cover of food and shelter or whatever.
Right.
You know, it cuts across communities.
My lord mentioned the example.
All religions have, you know, little children going into these institutions, the eleemosynary institutions, as they are called. For party.
So, my lord, as far as Buddhists, my lord, the lamas and monks are.
In community, most of the top sadhus or maharajas, Mahapragya is one name, others, have taken this diksha from very rich families, forget the protection, at the age of under 10.
Yes. So,
and they are from affluent families, which is unbelievable level of affluence. So that is not the criteria. It is really that it is something which, it's religious instruction. It's direct religious instruction.
Right. So may I respond to that? My lords, when we talk of, say, a Buddhist monastery,
and even today, there is no law which regulates so far as renunciation of world is concerned in this community at the age of 8 also, 9 also, 10 also, 12 also, 15 also.
Right. So, my lord, may I respond to that? So, my lords, in our country, yes, we have this tradition. Right. So, my lord, in response, I would say this. There are Buddhist monasteries and there's Diksha taking ceremonies at my.
But they are not governed by statute. That's the difference.
Those are monastic vows that those children have taken because either they have felt a calling or their parents have felt that calling for them. They are, my lord, in law, that is civil death, once you undergo that renunciation. I do not believe that these thousands and thousands and lakhs of children who go to madrasas are that their parents have signed up for them undergoing monastic vows or leading a life of, my lords, of religious, they are going to be in the real world. They aspire to be, but perhaps either they do not know or they have signed up. My lords, the children have foregone those opportunities. This is not a situation of a Buddhist monastery. It is not a situation of of Diksha taking ceremony where my learned friends absolutely right. But that is a very different, that's monastic vows. You're committing your life to either abstinence. These people are going to be in the mainstream. That's why we have equivalence. That's why, my lords, they become teachers in this very system, etc. So, my lord, these are not people who have signed up for that kind of life. So, my lord, that example, in my most respectful submission, would not be an appropriate one. So, my lords, this is meant to be a substitution for elementary or primary education to start with.
And it has a predominantly religious flavor. You say with virtually no secular
so, my lord,
credentials. He got your point.
Under
Guru also made the same point. We'll hear the others.
Yes. So, my lords, in our system, of course, my lords, religion is so important. It has identity, all of that. There's no difficulty with that, and that must flourish. But there is no conflict between having, as a mainstream person who has not taken monastic vows, of having a strong religious identity, of having all of that, practicing your religion, which allows you to aspire for the best. Then eventually, my lord, even children coming out of, say, government schools, etc., maybe they will not, but at least...
But then that's a matter of interpretational exercise for the court to say that, well, the stands today does give the state government sufficient avenues to interpret its provisions in such a manner that it can ensure basic level of education even in madrasas, consistent with some element of mainstreaming. That we can do as a matter of interpretative exercise without striking down the provision.
So
and your point is well taken on that.
So I will leave these thoughts on that with your lordships, because, my lords, the manner in which, and I'm referring to specific provisions, I'm not going to read them again, but, my lords, if your lordships looks at the definition of madrasa education,
we saw that.
Yes, coupled with the composition, overwhelming
of
composition
the board, section 3.
And, my lord, the fact that these decisions are taken by a majority under 7.3, section 7.3, it's a majority decision. So, my lords, there is one, my lord, NCRT member out of 14 persons over there who may have some background, and the rest of the secular members are, my lords, accountants.
That point is made actually about the Act definition and section 3.
Because, my lord, the essential character is such that, my lords, the state's interference under section 13 can't be contrary to the essential character. That's what I'm saying. And I'm going to show your lordships in practice, because if these are the persons with their special competence in their special case, if they are going to be setting a syllabus, they are going to be, my lord, conducting examinations, they are going to, my lords, award degrees, and they are going to fix qualifications for teachers. So we are creating, my lords, an ecosphere where these teachers, my lords, are trained in the very system. They are, therefore, my lords, they have an overwhelming emphasis. Their own training has an overwhelming emphasis on religious and a singular, my lords, outlook, and they are going to be imparting to these children. My lords, I am going to show your lordships to point out, and we have prepared an annexure in our written submissions where we show that there are the professional courses whether it is my lords, an engineering college, or it is biotechnology, or it is say going to the merchant navy, pilot, commercial, chartered accountant, architecture, none of this will necessarily be available to these children when they come out of these schools. And therefore, because, for example, now math or science is an optional subject. Now, my lord, why is this there? Because there's an overwhelming emphasis on certain kind of education, and the rest is, my lord, teachers. Yes. So that, my lord's, complete loss of opportunity, and therefore, my lords, it is striking at the heart of 21A. So,
in fact, your Mr. Guru Krishna Kumar made the same point actually.
So, my lord, page 22 of my written submission, your lordship may note, we've given.
What else, Ms. Diwan? What else apart from?
So now, my lord, one more argument on my lord, the fraternity argument. What my George also is. Now, my lords, when there is such an overwhelming emphasis on religious outlook. Now, I'm not, my lord, only on social status, economic opportunity, intellectual mobility. That is one aspect of the matter. But when your training is in that area alone, or that general outlook in life, then, my lords, perhaps, and this would be true again of any other religious community also, are you equipped? Is this education, with its overwhelming emphasis, is it equipping you to coexist and flourish in a multicultural society? Because you need to, of course, you need to be well versed in perhaps your religious as much as you want to, or your family wants you to. But at the same time, you must be able to engage with the other. You must understand that there are other viewpoints, and whether this kind of, my lord, skewed or lopsided education permits you to do that. And, my lords, therefore, my lords, in my respectful submission, it would create, and it is, we are seeing this in practice, that it does create islands. It is creating, my lord, islands of exclusion and othering. Because, my lord, one, you're not able to compete at the same economic level, the same, perhaps, my lords, academic opportunities are missed, and the fact that your worldview is of a certain one kind, which may be a very good worldview too, but the point is it ill-equips you to cope and engage with the rest of the world, and this is contrary, my lords, to the fraternity principle. You know, the echo chamber, in a sense, that it creates, and this is why, my lord, it is problematic. Of teachers, etc., my lord, 18-year-old Alim, etc., going to be a fan. So, my lord, it's completely different in the mainstream education, where even for an elementary teacher, you need, my lord, a diploma in elementary education in addition to a. Now, I understand, my lord, that in a socio-economic situation where there may not be means, it may not be possible. But basic outlook, and whether your lordships can tweak the Act to an extent that under Section 13 or any other provision, whether the state can interfere to that extent to destroy in some ways the basic character of the Act. That is the test. With great, I'm very.
Thank you, Ms. Diwan. Ms. Swaroop.
Lordships, I would like to highlight certain points and avoid maximum overlapping. But
so, what is the you are appearing for?
NCPCR.
NCPCR.
I'm appearing.
So, what is the basic point that you are making?
So, my lord, my NCPCR's written submission is there, but I'm just trying to present few paragraphs from the convenience volume, which is not filed by us, but at the same time, my proposal.
So, why don't you just formulate what you are arguing?
So, first thing what I want to highlight, the system, complete system of education which we are dealing with. We are giving too much focus on religious instruction, education and everything. And all judgments starting from Moynijan and Unnikrishnan have been dealing with that. There are three important stakeholders of this complete system. One, whenever we deal with any provision from 25 to 30, there are three important stakeholders. One is the government. Another is the administration. If I have a right to administer my institution, so the management part.
And third?
Third is employees. Most of the cases come, and even certain writ petitions here also through employees. The fourth stakeholder, which has been always ignored, is the children, and I'm standing here for them. Because we talk about a class which is our future generation. We plan everything, law comes from them. We adults sitting in the parliament, interpreting here, everywhere, we are deciding for them. So I clarify, we are not against agency PCR, any instruction. I just want to present the...
So has NCPCR then banned religious instruction in other communities or not?
My lord, I started with that when it comes to religious instructions, we are not against that. Like, I adopt Ms. Diwan's submission up to the extent we are a secular country, and secularism doesn't mean stalking anything. Secularism means that respecting others' culture. This is my view. So one paragraph, I would like to start my submission from 1899, which is Aruna Roy's judgment. I would read. I'm not asking my lords to go through, I just read. My lords have already made many paragraphs to be read by Guru sir. I'm just reading what I want to highlight. NFSC nowhere talks of imparting religious instruction as prohibited under Article.
But is it NCPR's case that little children in our country should not have to undergo religious instruction? Sorry?
Should not be deprived by their fundamental rights. And 21A is fundamental right. So the starting proposition is that is our main stand, that children's right, irrespective of their birth.
But you therefore accept, does NCPCR accept that little children from across religious communities in India's landscape do go to places of religious instruction and are trained in that particular religion?
Religious instruction must not be substituted as compulsory and compulsory education. That is what the question is here.
But therefore, has NCPR issued any directive that, look, whether cutting across communities, that you will not take children into your religious institutions unless these children are taught secular subjects?
Lordship, that is what NCPCR's stand is, that religious instruction should not be supplemented as the free and compulsory education. I need to take instruction to whatever institution they have.
So tell us, I mean, has NCPCR issued a directive that across communities, don't send children to any monastery, don't send children to any pathshala, don't send India to any...
Send. It is not in negative.
Okay, has NCPCR then issued a directive saying that, look, you must teach when children go to these monasteries or, these institutions, that they must be taught science, that they must be taught math, that they must be taught...
Repeated recommendations have been sent from the beginning till now. From 6 years, I am representing them. Repeated instructions to the state governments that the free and compulsory education...
So we're not talking of generally free and compulsory education, about the quality of the religious instruction, that there should be either that religious instruction in places of religious instruction for children must be predominantly secular with only a sprinkling of religious instruction.
It's not been come until the inspections on madrasas started. Now about...
Why are you only concerned with madrasas? We would like to know whether you've dealt with other institutions.
That I'll see. Now, Lordship, I just need to complete this paragraph.
Because we want to know, is NCPCR being even-handed in its treatment of all communities? Show us those instructions that you have said this across communities.
She should file this for other.
We'd like to know which are those instructions which you have issued. To whom have you issued those instructions? When were they issued?
To comply with the directives that free and compulsory education must be available to everybody. Now, not to institutions as such that nobody should send to the children. There are two different things. NCPCR being a statutory body to monitor the implementation of Right to Education Act has only recommendation power, not to...
No, but we see that. But NCPCR is aware of the fact that, there is religious instruction provided across India to young children who go to institutions of their communities. Has NCPCR adopted the stand that this is contrary to fundamental constitutional values?
Yes.
Or that? Show us where have you said that?
Seeking instruction, just a week ago, there were some reports also published. I'm just taking it, and maybe with additional written submission, I will bring on record. Now, I want to start with the fact that 21 talks about that when it comes to religious instructions. What is sought is to have value. I'm reading page 1899.
Yes.
What is sought to is to have value-based education, and for religion it is stated that students be given the awareness that the essence of every religion is common. Only practices differ. There is a specific caution that all steps should be taken in advance to ensure that no personal prejudices or narrow-minded perceptions are allowed to distort the real purpose. Dogmas and superstitions should not be propagated in the name of education about religion. What is thought to be important is incorporated in Article 1AE, which provides to promote harmony and the spirit of common brotherhood among all the people of India, transcending religion, linguistic, and regional.
That's all right. That's a general.
General. That is, so we are talking about the meaning of education in this context. Then there is a judgment at page 3135, Bharatiya Seva Samaj. Bharatiya Seva Samaj, and I am taking para 15 from the compilation volume at page 3135. Volume 5A at page 3135. The judgment is Bharatiya Seva Samaj. I am reading para 15 of the judgment.
Studied the syllabus thoroughly, and CPCR whom you are representing? Has this institution whom you are representing has studied the entire syllabus?
Lordship, they have.
That syllabus talks about religious instructions.
That they have studied at least for
So what is,
questions I have seen.
what have they understood? What is religious instructions? It seems you all are mesmerized and enamored by this one word, religious instructions. And that is why you are not getting out of it.
Lordship, I said
The entire premise of the arguments is on a not on a correct basis.
Lordship, I am not against that instruction. First, I said
there are no instructions.
Fundamental right.
Ma'am, there are no instructions. There's a fine distinction between religious instructions, which Article 28 is talking about, and the medium in which the education is imparted.
Lordship, I'm just coming to that. I'm just setting the background to explain what we understand as education and religious education, and that's where we say that we are only concerned about implementation of availability of fundamental right to education to all children irrespective of their family background. That is my basic proposition. So article say para 15 at page 3135 says, thus in view of the above, it is evident that imparting elementary and basic education is the constitutional obligation of the state as well as society's.
All right, we'll read that. What's the point? Next point that you want to make? We'll read that. Bharatiya Seva Samaj, we made a note, page 3135, para 15.
And then paragraph 16 also, my lord.
Right, we'll just
discuss with Ashok Kumar.
Yes. What else, Miss?
Then I'll just read few provisions of Constitution to show that there is no conflict. As we are seeing 21A and 28(9) in conflict, there is no conflict in my view. So I'm just reading the main provision starting from Article 15, which is in compilation volume at page.
That's okay. We've got the Constitution with Article 15. No, don't read Article 15. I mean,
prohibition of discrimination.
That's okay. Don't read it. Just tell us the articles you want to rely upon.
Establish that this by state bypassing another system to provide education while avoiding the liability under Article 21A is hit by Article 15, which is discrimination on the basis of religion. So children studying in one particular institution, state should not look at it as a supplement to their obligation, which is given under Article 21A. So to establish that, I'm just relying upon Article 15. Then I'm moving to Article 21, protection of life and personal.
All right, then.
So that 21A is put at the place with the intention, because it is connected that the right to education is to ensure the right to.
All right, 21A, yes.
which Ms. Diwan has said. So I'm just
What else?
Without repeating that children up to from 6 to 14 do have right to live with dignity, and without realization of 21A, it is not possible for them to do that. Then I'm moving to Article 25, freedom of conscience and free profession. So right to freedom of religion is starting from 25, 26, 28, which I said to begin with, talks about one side of a stakeholder where one can propagate and profess their religion, but at the same time, it is nowhere saying that any fundamental right available to children should not be given. So at the place where it is starting again 29-30, cultural and educational right, the wording of Article 29 and 30, I would like to read. 29, protection of interest of minorities. Any section of the citizen residing in any territory of India or any part thereof having a distinct language, script, culture of its own shall have right to conserve the same. No citizen shall be denied admission into educational institutions. So here it is limited to right to get into education system. Rights within the education system.
If you have given us your written submission, so we'll be rising now.
If not is having it tomorrow, then
No, tomorrow we have another matter now. We'll have to close it today for judgment now.
So I need 5 minutes more.
All right, 5 minutes be there.
So no citizen shall be denied. When it talks about 29, here also it is talking only till the admission, which is often in all judgments interpreted as the rights of the administration. But the children's right to get into that, and what is rights within the education system, right to get education and rights ensured within the system are two different things, Lordship. So that part in none of the judgment is yet acknowledged. Article 30 again, right to minorities to establish and administer education institutions. So 30 is completely upon administration, establishment. So whatever judgments are referred on these issues, which are said that it can be exemption. Exemption doesn't mean that it is exemption for the fundamental right not to be given to the children who are into those institutions. So there are two different stakeholders. All judgments are talking about the right which is ensured under 30, and that 30 doesn't make any exception that the children right would not be protected. Then next point is para 65 of the impugn order. I'm not reading, I'm relying upon that. Text.
Regulatory.
So para 65 of the impugn order, which talks about the syllabus, I'm not repeating, I'm just trying to say that it is already argued that it talks about all compulsory subjects which enable a person, a child to get into professional colleges are optional. Whether it is physics, chemistry, science, maths, anything and everything is optional, or only the language is there. Only one, and the option is to choose only one. They cannot choose even if they want more than one, because I could not see any provision, and High Court has rightly relied upon this situation to have it against the right to dignity. Then I'm moving to the argument of Rights to Education Act, which was to enable children from 6 to 14 as their fundamental right. And the section 1 subsection 4 and 5.
These children will not live a dignified life. That's your argument.
Lordship, we are saying state is bypassing its responsibility while enabling this because it is seen as not as supplement. It is seen as an alternate to the right to education. That is where the problem is. If it is in addition, it is definitely a good thing. We all should know about all religions. At least I have studied most of them. But only thing is where it is treated as an alternative. That is the problem. If it is supplemented, it must be there. It must be encouraged. The state must do that. But the state is bypassing its obligation, which is given under 21A, while creating this, because this is how it is being seen as an alternative. That is where my problem lies. If it is supplemented, it must be there. It must be encouraged, and it would rather add on to live a more dignified life. But the problem is with treating it as an alternative, Lordship. Then the exemption part, Lordship has put the question that the exemption that RTU would be applicable or not. In my respectful view, where it says that it would not be applicable, again, it is about right to establish and administer, because that is what 29 and 30 is. It is not about the basic fundamental rights available to children in other part of Constitution. They would be deprived from that. So in my respectful submission, there cannot be any reading of this provision as it would deprive a class which is a future generation to deprive them from their
Let me just give the other side now 7 minutes to for a rejoinder before we.
See that, Lordship, your comment, I'll just, because the property, I have to deal with the property. In my
UGC Act, what do you have to say? UGC Act?
UGC Act and property, only 2 points, 1 point.
UGC Act, I think we are on, there's a notification of 2014 which you showed us.
So
that point is clear.
Pramati, just one line. Again, the Pramati is pari materia as far as RT is concerned from that is stakeholder in my submission, because again, the issue was about establishment and the administration.
Very kind with the time. We are going to give really bullets in 2 minutes or 4 minutes. Not less to rights. So I want to make 3 points. The first is, Willis, that your Lordship has something like a removal of difficulties clause in some other statutes, where your Lordship already has case law, which gives a fairly good power to tinker, change, fill in gaps, cure defects, etc. If your Lordship sees 13 in this Act, it is far bigger than a removal of difficulties clause. 11 and 13 of the main 2004 Act go together and gives the state comprehensive power. Lordship will note 3 provisions: 11, 13.1 and 13.4. And 13.4 is the most important. With this comprehensive power, add my first point with which I opened when I argued the main matter was earlier, the first day Lordship passed the detailed interim order. The fundamental pernicious aspect of this exercise is throwing the baby out with the bathwater. And the bathwater itself is not very dirty at all. Again, the baby wins. With this power, you should improve, suggest, be constructive, modify. But you say, no, I'll ban. Well, let us not forget, this is nothing but BAN. The way it came to the High Court. And that too with a non-locus, local-less petitioner.
But there is no ban also, because the state has not banned.
Yes.
The High Court which struck down the Act.
And ironically, the High Court has one very detailed paragraph, which says we must regulate and not ban. And then proceeds to the opposite. That's point number 1. Now, your Lordship will therefore link my original argument, which my Lord has noted in para Roman small 6 in the original order of my Lord's Willis, that order of 5.4.24, para small Roman 6. So these 3 points link, Willis. You have power in the 11, 13.1, but I will say a very broad plenary power in 13.4. 13.4. Far beyond Willis removal of difficulties. Your Lordship's case law and removal of difficulties carries you quite far. But this is far beyond that. So why should you exercise this power? Why should the state not be asked to fulfill it? That's Willis point number 1. So banning is not the solution. Throwing the baby out of the bathwater not the solution. Point number 2. Please turn to 915 of volume 3A at 917. Well, some things are inconvenient. You give the dog a bad name and hang him.
Volume?
Show these things.
Volume
915 at 917.
Of
volume 3A. Correct?
That is, we saw that those minutes.
Minutes. Now, no, so therefore, the minutes are crystal clear about modern subjects. What is the date of these minutes, fellas? October 2021. Now, where are they gathering dust? They are gathering dust with the state government where they've been sent for approval. It would have taken 2 days to approve this. We are in 2024. Yes. In 917, please turn to the para I invited Lordships to Malas. Lordships got para 7, just 2 minutes.
Yes.
What is the PDF of 917?
917 is
917.
PDF.
917.
Thing is important. After extensive discussion regarding the curriculum implemented in madrasas, the council, this is the Madrasa Council, forget the individuals, unanimously approved the inclusion of elementary maths and elementary science, history and physics as compulsory subjects. We've been hearing about Oxford the last 2 or 3 days. From class 1 to secondary level, as per curriculum, consent was granted, sent. I am asking my second point, why did you not approve it? That's why I use the phrase, give the dog a bad name and then hang him. Oh, you didn't do it, don't do an optional.
It was sent to the state government for approval?
21. And reminded umpteen times.
Why was approval required?
Section 11 required.
11.
Yes. Now, this is part of the curative process. If you have perceived any gap or lacuna, you want to not have that curative process, so you can give a bad name and then
11 requires prior approval to recognize any institution in any new subject. It was not required. In fact, those minutes don't say that we are sending it to the state government also.
Sent by letter subsequently. Just recognition of an institution in any new subject for a higher class.
Teachers.
All aided.
Teachers are not appointed. Teachers' salaries are not paid. We have to have their approval. Otherwise, they will not sanction teachers.
All institutions on our side partially aided. There is some aid involved. Therefore, it will not happen without us getting approval.
So salaries are paid or
government. And it also says, if you just glance at 11, recognition for any new subject or for a higher class. Now, it can be called a new subject because it is becoming compulsory. I mean, it's not a new subject in that sense, but it can be called. Because entire secondary is still class 10. So that's the other thing. Now, your lordship has noted that all modern subjects can be taught in any language, English, Hindi or Urdu. That was shown to your lordship in the regulation. 171, volume 4A. I'll just take 3 minutes. It's important.
2 minutes. 5.
171, volume 4A, post amendment way back 5 years ago in 2018. It reads thus. May I read, don't open it?
Yes.
Regulation 10, the statutory regulation is amended. And 10H after amendment reads thus. Teaching of all the subjects can be imparted. The medium of instruction in Diniyat and other Arabic, Persian subjects shall remain in Urdu, Arabic and Persian. The medium of instruction in maths, science, social science, computer, etc. is important. Shall be Urdu, Hindi or English as the case may be. These are inconvenient truths if you want to paint me black. Now one more point and I come to a second point after that contentious point. The point I am with great respect, your lordship is hearing argument after argument by various learned counsel on that side on 28 and on the Aruna. Just don't go into it, just note my points. 28.1 is clearly accepted by 28.2 on textual alone, forget any case for we are aided in terms of at least salaries and some other ways, all of us here. So we will fall to that extent under 28.1 and 28.2. So 28.2 to put it loosely, will rub off 28.1. If there was any doubt, 9 judges in Xavier have held so. 3 learned judges in Anna Roy, apart from all the other paras which we did in the opening, your lordship will mention, I am not taking your lordship's time. So how are we hearing arguments on 28.2 today is my question to myself. A second argument I'm asking myself, how are we hearing? Again and again, RTE. Well, RTE came in 2009. Your Lordship amended the RTE on 2012, 1/8/2012 to be precise, by inserting 1 bracket 5, which exempts by a specific statutory amendment. We are hearing argument after argument, RTE. Now, fortunately and happily, even this PIL petitioner, however intrepid he is, did not challenge 1 bracket 5. Certainly, I have not challenged it. Certainly, they have not challenged it, nor is NCPR thought of challenging its own act. Well, the NCPR should actually challenge 1/5. Your Lordship, by a constitution bench, has upheld the RT. So, on the law, if you marry 28 and 1 bracket 5, with greatest respect, what remains in the law with 9 judges in Xavier and 3 judges in Aruna? That's point number 2. Now, his third point is contentious, and let me end in 2 minutes on that. About the UGC. Now, just bear in mind, 2 facts. Fazil and Kamil are 150 odd years old in terms of continuing education in India. That's point 1. I'm going to suggest a solution. I see what my lord is saying, and I'm going to suggest a solution. Prior to the ASG producing a notification, it was believed that 22 does not deal with this as a degree, and that was the common understanding. Now a notification has been produced which says that it is not. I mean, it will go out. It will not be considered a UGC. This is postgraduate and undergraduate, which is higher degrees in school, on things like serious study of Persian and Arabic in terms of language, but also one of the Islamic culture, Islamic culture. Now we accept that this is not a degree, and your Lordship, we don't. I mean, in the fullness of time, they may or may not notify. This is a different matter. Well, I am suggesting 2 things. Either, we will give Fazil and Kamil, whatever institution is giving, with bold-faced letters saying these are not degrees under or recognized by the UGC Act. This is a completely non-trick-based, non-invasive, non-prejudicial. If I am giving you a degree saying with bold-faced the disclaimer, how can you have an objection? I don't claim to be X, then don't castigate me as pretending to be X. And I will make it in any format, any lettering, any size. Like a statutory warning about health. Alternatively, and this is important, this is an alternative suggestion. There are 6 documents from 2002 onwards all the way to 2011. I have the pages, in volume 3A. You'll also just quickly note the pages from 946. These documents are important. Sorry, 848. I'm sorry, apologies. 848, 850, 853, 866, and 868. They are all in volume 3, capital A. All these are periodic, repetitive letters by the state government recommending that, only recommendation give, that this institution or college should be given the status of university to enable them to give Fazil and Kamil degrees. In particular, they are focused on the Rampur Madrasa Act. Oriental College Rampur. Now, that is in recognition of 150 years legacy and tradition. So my second alternative suggestion is that, in the light of these, let there be at least one institution in Uttar Pradesh which is recognized to do this. There is no, how will it not be public interest? One institution, a person wants to study a postgraduate. Now, I've given these pages. This is different. Yeah, that's easy. These 6 documents all say give any one institution, particularly this very eminent institution, a deemed university status, so it will come under UGC. Now, you are not giving it to multiple, nor are you giving me the power to create an institution to teach Fazil and Kamil. I am not claiming that. Why should your lordship not preserve a 150-year legacy with this solution? Is the alternative argument. That's all. A very deep question.
Thank you. Yes, Mr.
But three suggestions of the applicant, the lordship may and we have copies. Three suggestions the lordship will consider. One is appoint teachers. They are not appointing teachers. This was always through the education department. You have transferred it after 1995. Give it back to the education department. And the third is make service conditions for the teachers. All that is within the power of the state government. Those are my statements.
That we have seen. Haraford.
One very short point, your lordships may simply note, my lords, page 390 in Xavier's, which is a 9-judge bench decision. This is 390, volume 4A, on the concept and the high value of so-called secular education. My lords may just read that one paragraph, and it says this: the concept has nothing to do with an artificial government promoting leveling of all differences. The public school is not a temple in which all children are to be baptized into the unity of secular democratic faith, while those who stand without are fatally heretic. 9 judges, and it also speaks to the rights of parents to choose what mode of education, which my Lord Justice Pardiwala pointed to. This is 9 judges, Xavier's.
Well, may I just flag one last concern? Yes. Because there was a discussion on whether lordship will find some solution, but the Fazil and Kamil, are the qualifications used for teachers going into madrasas? Because if there is any observation about this not being a degree, should reflect upon their qualification to join madrasas as teachers. Just a concern that I thought I'd flag for.
The report that was pointed out by learned senior counsel on behalf of NCPCR, this report is here. This is titled Constitutional Rights of Children versus Madrasas. So this is exclusively on madrasas, and the content is such I can't read in open court, my lord. This is so objectionable. They have taken newspaper reports, put it as Islamophobic report, statements, put it in the report, and this is being circulated on the ground. This is being given to the media houses, and they are doing debates on this, my lord. And second, my lord, as far as Article 21 is concerned, to give effect to Article 21, the solution is that you go and request the estate to open general school, which they call mainstream school, which we all agree. They should open more and more schools in Muslim dominated areas where madrasas exist. These institutions will automatically become secondary. Rather than saying that you first close it, that's all. That's the
Item for the UGC merit power matters will retain the position after.
Yes, Manoj.
Still here by any chance?
The main council had to leave due to
Yeah.
As per the instruction received from the UGC, there are no further notification after.
But 2014 notification still holds a field. So therefore, the Fazil and Kamil is not a recognized degree. He is not, rather it is specifically mentioned in the schedule to the notification, and therefore it is not outside the purview of section 22(1). 22(1), the prohibition in 22(1) of the UGC Act will apply.
In item 36.4,
all right, no different.
But in item 36.4,
I can tell you retain position after validating rate pattern.
Yes.
But But in item 36.4, I'm providing the
Tomorrow
brief.
we'll hear Mr. Gopal Shankarnarayan and marital rape first on board tomorrow.
But in item 36.4,
Okay, we list.
but in item 36, in item 36.4, I am providing the brief outline of my oral submissions along with the relevant Allahabad High Court rules.
I was wondering, I was looking at that. Thank you. Thank you everyone for your assistance. Thank you.